The House will come to order. So members, the next order of business are requests to concur with Senate amendments. We are going to go ahead and skip the first one on our list, which is message 324, until Chairman Burkhart gets to the chambers. So the first message for our consideration is message 327. Chairman Olson.
Okay. Mr. Speaker Pro Tem, I move message 327 to House Bill. So
House Bill 85, Mr.
to
Chairman.
House Bill 85 and do ask for your favorable consideration. This is the unlawful dissemination of intimate images. And so I'm looking for the good sponsor of the bill, but I don't have to turn it over to him if he doesn't want, he's in favor of this concurrence. And what this is this, I mean, if you want to talk on it? Nope. Okay. I've talked to the sponsor on this, obviously, to get his blessing on what he wants to do here. And what all the Senate did was adjust the penalty from 6 months to 1 year. It's still a misdemeanor, So if you want to, Wyoming doesn't really have a high, classification of misdemeanors, but you could just call this a high misdemeanor is really what it is. So still a misdemeanor. It's a good concurrence. And so I'd ask for your favorable consideration. Thank you, Mr. Speaker.
Right. Members, we are on message 327, which is a request to concur on House Bill 85. Any members for a first time? First time? Second time? Second time before the movement? All right, sensing you're ready to vote. We are voting on the motion to concur with Senate amendments to House Bill 85. A majority of the elected members is required. The chief clerk will call the roll.
Andrew, Baker, Banks, Bear, Blackburn, Brown, Burkhart, Burt, Clausen, Clifford, Connolly, Crago, Duncan, Eklund, Air, Flitner, Fortner,
Aye.
Gray, Greer,
Aye.
Hallinan, Haroldson, Harshman, Heiner, Henderson, Hunt, Jennings, Kenner, Knapp, Larson Lloyd, Larson Dan, McGuire, Martinez, Nyman, Newsom, Nicholas, Oakley, Obermuller, O'Hearn, Olson, Ottman, Paxton, Provenza, Roscoe, Schwartz, Sherwood, Simpson, Summers, Stith, Stivar, Sweeney, Walters, Washit, Western, Wharf, Williams, Wilson, Winter, Yin, Zawanitzer, Mr. Speaker, Flitner,
Excused.
Henderson,
Excused.
O'Hearn,
Excused.
Washit,
Excused.
Western,
Excused.
Williams.
Excused.
Closing vote. Are there any changes? Closing vote. The vote is closed. 52 aye, 1 no, 7 excused.
by your vote, you voted to concur with House Bill 85 of the Senate, or you voted to concur with the Senate amendments to House Bill 85. The next message for our consideration, excuse me, go ahead, Representative Duncan.
Thank you, Mr. Speaker Pro Tem. Real quick, privilege of the floor.
Go ahead.
Thank you. For all of those, I think he's still here. Look up top. The others weren't able to make it back, but we need to give a big thank you. This is another round of our lunches of people who are here. Petroleum Association of Wyoming is Pete Obermueller. We also have, they had to go off to a different committee, but we also have Lori Urbichite, Charlene Kaiser, and Kyle Urbichite. They had the Wyoming Realtors, Wyoming Airport Coalition, Wyoming Horse Racing LLC, and Wyoming Business Alliance is Cindy Delancey. So big thank you to them.
Okay, the next message for our consideration is message number 324 to House Bill 22. Chairman Burkhart.
Thank you, Mr. Speaker Pro Tem. I move concurrence on message 324 to House Bill 22 military or Wyoming Military Code and ask you to vote no. What our friends down the hall did was they made a slight modification and changed the wording for attorneys shall include admission to practice law in Wyoming. And what they changed that was in effect to be a member of good standing of the bar of the highest court of any state in the United States and admitted to practice in any federal court or hold a current position as military judge advocate. Now, this was put in there by our friendly attorneys down the hall, and in talking to the attorneys here, they feel there may be some problems with that wording. So I would ask you to vote no. We'll get together and have a discussion on this.
Okay, any further discussion on the message? Any further discussion? Since we're ready to vote, we are voting on the motion to concur with Senate amendments to House Bill 22. A majority of the elected members is required. The chief clerk will call the roll.
Andrew, Baker, Banks, Bear, Blackburn, Brown, Burkhart, Burt, Clausen, Clifford, Connolly, Crago, Duncan, Eklund, Air, Flitner excused, Fortner,
No.
Gray, Greer,
No.
Hallinan, Haroldson, Harshman, Heiner, Henderson excused, Hunt, Jennings, Kenner, Knapp, Larson Lloyd, Larson Dan, McGuire, Martinez, Nyman, Newsom, Nicholas, Oakley, Obermueller, O'Hearn excused, Olson, Ottman, Paxton, Provenza, Roscoe, Schwartz, Sherwood, Simpson, Summers, Stith, Stybar, Sweeney, Walters, Washit excused, Western excused, Wharf, Williams excused, Wilson, Winter, Yin, Zawanitzer, Mr. Speaker, Blackburn,
Excused.
McGuire,
Excused.
Newsom,
Excused.
Sweeney.
Excused.
Closing vote. Are there any changes? Closing vote. The vote is closed. 1 aye, 48 no, 11 excused.
By your vote, you voted not to concur with Senate amendments to House Bill 22. So members, Representative Olson, Chairman Olson.
You might be about to say what I'm going to say. I'm not sure, but Mr. Speaker Pro Tem, I was just going to take the privilege of the floor, if I may, just for the public out there, may have gone through a series of excused, but we've entered that time of bill signings. So we have members off the floor who are at bill signings, and just want to make sure the public is aware that our members are sometimes in multiple places at once. Thank you, Mr. Speaker Pro Tem.
Yeah, thank you, Mr. Whippen. We also had the TRW committee, I think, returning back, and those members should be here shortly. And then again, I know we've got 2 or 3 members off for a bill signing. So with that, folks, I'm going to take things out of order just a little bit to let the good chairwoman of TRW gather her thoughts. And so the next message for our consideration will be House Bill 68.
Message number, reading clerk will read the message. 330. That's Chairman Greer.
Thank you, Mr. Chairman. I move message 330, concurrence request to House Bill 68, Wyoming Statutory Foundation Act amendments. And members, I'll ask for a favorable aye vote. If you look at the amendment on page 3, I think we're talking about the charitable purposes, and how we reworded it before. It talked about if the charitable purposes are. Instead, we turned around and it says charitable purchase or purposes which is achieved. And so the R needs to be changed to an is. It's a technical correction associated with grammar. Really no need to discuss it any further with the Senate, and I vote would be awesome. Thank you.
Is there any discussion? Seeing none, we are voting on the motion to concur with Senate amendments to House Bill 68. A majority of the elected members is required. The chief clerk will call the roll.
Andrew. Baker. Banks. Bear. Blackburn. Excused. Brown. Burkhart. Burt. Clausen. Clifford. Connolly. Crago. Duncan. Eklund. Air. Flitner. Fortner.
Aye.
Gray. Greer. Hallinan. Haroldson. Harshman. Heiner. Henderson excused. Hunt. Jennings. Kenner. Knapp. Larson Lloyd. Larson Dan. McGuire excused. Martinez. Nyman. Newsom excused. Nicholas. Oakley. Obermuller. O'Hearn excused. Olson. Ottman. Paxton. Provenza. Roscoe. Schwartz. Sherwood. Simpson. Summers. Stith. Stibar. Sweeney excused. Walters. Washut excused. Western. Wharf. Williams excused. Wilson excused. Winter. Yin. Zawanitzer. Mr. Speaker. Larson Dan.
Excused.
Roscoe.
Excused.
Closing vote. Are there any changes? Brown? Closing vote. The vote is closed. 49 aye, 11 excused.
By your vote, you have voted to concur with Senate amendments to House Bill 68. The next message for our consideration is message 328. It's House Bill 101. Chairman Flintner.
Thank you, Mr. Speaker Pro Tem. I move concurrence on message number 328, and I ask for your aye vote. Members, this is related to House Bill 101, which is elk feed ground closing requirements. In speaking with the bringer of the bill, he's amenable to the changes that were made at the other end of the building. Simple changes with regard to bringing in the livestock board just as a consultant when conducting public meetings and providing comments to the executive branch. And then also the report requirements to your committee number 6. The other body brought in the cost of implementing the contingency plans to ID appropriate lands in the advent of relocation of any elk herds. So barring any questions, I would ask for your aye vote.
Okay, are there any questions on message 328, House Bill 101? Any members have any questions? No, sensing you're ready. We are voting on the motion to concur with Senate amendments to House Bill 101. A majority of the elected members is required. The chief clerk will call the roll.
Andrew. Baker. Banks. Bear. Blackburn excused. Brown. Burkhart. Burt. Clausen. Clifford. Connolly. Crago. Duncan. Eklund. Air.
One more step. There you go.
Flitner. Fortner.
Aye.
Gray. Greer.
Aye.
Hallinan. Haroldson. Harshman excused. Heiner. Henderson excused. Hunt. Jennings. Kinner. Knapp. Larson Lloyd. Larson Dan. McGuire excused. Martinez. Nyman. Newsom excused. Nicholas. Oakley. Obermuller. Obermuller. O'Hearn excused. Olson. Ottman. Paxton. Provenza. Roscoe excused. Schwartz. Sherwood. Simpson. Summers. Stith. Stibar. Sweeney excused. Walters. Washit excused. Western. Wharf. Williams excused. Wilson excused. Winter. Yin. Zawanitzer. Mr. Speaker. Closing vote. Are there any changes? Bear? Aye to no? Oh. Closing vote. The vote is closed. 48 aye, 2 no, 10 excused.
By your vote, you have voted to concur with Senate amendments to House Bill 101. The next message for our consideration is message 332, House Bill 112. Chairman Flintner.
Mr. Speaker Pro Tem, thank you. I move concurrence on message number 332 to House Bill 112, Pioneer Trapper License. And I would ask for your aye vote. In speaking with the bringer of the bill, he concurs with the changes made by our colleagues down the hall. Basically, one was a grammatical change and the other was a typographical change. So please vote aye.
Any discussion on message 332? Members, any discussion? Sensing you're ready to vote, we are voting on the motion to concur with Senate amendments to House Bill 112. A majority of the elected members is required. The chief clerk will call the roll.
Andrew. Baker. Banks. Bear. Blackburn excused. Brown. Burkhart. Burt. Clausen. Clifford. Connolly. Crago. Duncan. Eklund. Air. Flitner. Fortner.
Aye.
Gray. Greer.
Aye.
Hallinan. Haroldson. Harshman excused. Heiner. Henderson excused. Hunt. Jennings. Kenner. Knapp. Larson Lloyd. Larson Dan. McGuire excused. Martinez. Nyman. Newsom excused. Nicholas. Oakley. Obermuller. O'Hearn excused. Olson. Ottman. Paxton. Provenza. Roscoe excused. Schwartz. No. Sherwood. Simpson. Summers. Stith. Stibar. Sweeney excused. Walters. Washit excused. Western. Wharf.
Aye.
Williams excused. Wilson excused. Winter. Yin. Zawanitzer. Mr. Speaker. Closing vote. Are there any changes? Brown, no to aye. Further changes? Closing vote. The vote is closed. 48 aye, 1 no, 11 excused.
By your vote, you voted to concur with Senate amendments to House Bill 112. So members, we're going to go ahead and hold off on message 133 till we have a full floor at the request of the chairman. So the next order of business is adoption of joint conference committee reports. Chairman Zwanitzer, would you mind?
We are on Joint Conference Committee report to House Bill 7. Chairman Greer.
Thank you, Mr. Chairman. So I'll move the Joint Conference Committee report to House Bill 7 and ask for an aye vote. I don't have the exact bill in front of me, so that my good representative friend, co-conferencee from Campbell County will back me up if need be. But so basically, if you recall, this is the air ambulance service. And so the work that was done several years ago, we had passed a law that required that these air ambulance membership organizations would have to fall in and be regulated like an insurance company. Well, they're not insurance companies, they're membership companies. And these are used throughout the state of Wyoming and in particular in my county very effectively. So as we come to look at this again, what we decided is one of the concerns had to deal with consumer protection. And that was maybe high pressure sales pitches with a free lunch or a dinner and people getting sold memberships who really didn't need them, people on Medicare, for example. And so as we worked this bill through the interim, and then again, as the House Standing Committee really did work that just before we came into the virtual session, what we did is we put in a series in this bill of consumer protection laws. That is disclosures and things that couldn't be said, and the time to withdraw your membership, and to make it clear that if you have a membership and you're in a certain area, you may not get the air ambulance service provider that you're covered for, things like that. Well, and it came out of this body in really good shape, very good shape, to allow us to go forward in the state. Went over to the other side and they put in much more stringent requirements. And they were requirements for financial disclosures and to allow the insurance commissioner to audit books and a lot of things that were going to drive this business out of the state of Wyoming and not allow them to operate in areas like mine. So we went to the conference committee, good committee from this house. We good discussion, went through the issues, and in the end, what we ended up doing was accepting the Senate's cleanup items on a couple of these, and then also they had a few more add-ons on the consumer protection, but they agreed to pull out all of the financial responsibility, all the burdensome regulation to follow the wishes of this body. I would have to say at the end of the day, it was a very successful. The House position was honored, low regulation, and just as what we were trying to do with this this whole system is have regulation light, just a small amount of consumer protection, which was advocated for by all of these membership providers, by the way. They don't want bad actors. They want a certain amount of consumer protection because it's good for their business not to have bad actors in that. So with that, again, a real good discussion with the Senate, like the result where we are, very happy with it, and would ask for an aye vote.
So members, just for your information, if you do want to see a copy of Joint Conference Report number 1, it is on the website under the bill. There will be a tab on the LSO website, and you look at House Bill 7. Under the amendments, it'll be Joint Conference Committee Report number 1. With that, is there further discussion on the Joint Conference Committee report? I might give members a couple of seconds to pull it up before we call the question. Again, it's on the LSO website under House Bill 7 under the amendments tab. Mr. Vice Chairman Larson.
Thank you. The good Chairman of Minerals. I've been following this over the last year, and I appreciate what the committee has done. But in reference to disclosure of the financial status of the company, you suggest that that does not then allow, if we would have kept that in place, that does not allow them to operate in the state. And I'm not sure that I understand why that would be. They may elect not to operate in the state if they're required to show their financials, but just on what I heard you said, they would not be allowed to work. And so if you could clarify that with me and help me to understand that.
And we do have debate rules apply. Representative Bear.
Thank you, Mr. Chairman. In response, you are accurate when you state that they could continue to operate, but the regulations really would be onerous, and there would be conflict with federal law as well, because we've got these particular operators are covered under the Airline Deregulation Act of 1978. So there becomes a conflict with federal law. And so they choose not to operate based on that and these additional regulations.
Is there any other discussion for the first time? First time in Joint Conference Committee Report number 1. Second time, Vice Chairman Larson.
So thank you, Mr. Chairman, and I'm trying to understand, to disclosure financial, how is that in conflict with federal law that deregulates the regulation of pricing for air service? That has nothing to do with setting the cost. And so I'm trying to understand if you're saying that's in conflict with federal law, can you help me understand that?
Representative Bear. For a
Thank you,
second
Mr.
time.
Chairman. I'm not going to be able to answer that precisely because I'm not an expert on that particular part of federal code, but I can tell you that these things have been adjudicated to the district court level. And these particular organizations have been found that they cannot be regulated by states under the insurance regulations. That's the only answer that I have for you.
Chairman Greer, take us home.
Thank you, Mr. Chairman. To answer the good Vice Chair of Appropriations question, so he quits shaking his head like a three-legged cat. The simple fact of the matter is these are membership companies that go out and they gather up memberships in areas, and then they contract with the air ambulance providers, the people with the airplanes, with the helicopters, with the doctors and nurses that are on board. Okay, and then they have their agreements with them for the charges for the services. And then what they do is they'll bill our insurance company. But if there is a charge above what the insurance company pays, or you don't have insurance, or you have Medicare and it only pays a certain amount, there's no balance billing. That's the deal that you get with an air ambulance membership. And so the concern was with the companies that were within the state is if the insurance commissioner was able to go in and if all of this information was made public, they would be in essence making public their entire business plan, which would disclose their arrangements with the providers of the air ambulance service itself, the people with the airplanes. And that's where we had this problem. And they said, boy, we would not be able to operate in Wyoming if we had to disclose our entire book of business, our entire business plan. So hopefully I've answered that question and hopefully you all vote yes. Thank you.
We are voting on Joint Conference Committee number 1, report on House Bill number 7. The majority of the elected members is required to adopt the report. The chief clerk will call the roll.
Andrew, Baker, Banks, Bear, Blackburn, excused, Brown, Burkhart, Burt, Clausen, Clifford, Connolly, Crago, Duncan, Eklund, Air, Flitner, Fortner,
Aye.
Gray, Greer, Hallinan, Haroldson, Harshman, excused, Heiner, Henderson, Hunt, Jennings, Kenner, Knapp, Larson Lloyd, Larson Dan, McGuire, Martinez, Nyman, Newsom, Nicholas, Oakley, Obermuller, O'Hearn, Olson, Ottman, Paxton, Provenza, Roscoe, Schwartz, Sherwood, Simpson, Summers, Stith, Stybar, Sweeney, Walters, Washit, excused, Western, Wharf, Williams, Wilson, Winter, Yin, Zawanitzer, Mr. Speaker, Haroldson, excused. Closing vote. Are there any changes? Burt, no to aye. Further changes? Closing vote. The vote is closed. 53 aye, 3 no, 4 excused.
By your vote, you have adopted Joint Conference Report number 1 on House Bill 7. We will now return to concurrence requests. The next message up for our consideration is message number 334 on House Bill 133. Chairman Nicholas.
Mr. Chairman, I would move Senate Message 334 and move for concurrence on House Bill 133, and I'll turn the explanation over to the good Representative Casper.
Representative Walters.
Thank you, Mr. Chairman. I would encourage an aye vote on concurrence. And members, the House sent a spiffy little bill down to the other end of the hall, and they added a few nifty amendments that improved the bill. So the first nifty amendment that they did is they extended the deadline for rulemaking from the 1st of July to the 1st of September. The second one they did is they eliminated the ability for a operator to get a temporary permit, which I think is a good thing. Third, they added some language for the commission to develop a compliance program that includes establishing procedures to review wagering as well as related activities to ensure compliance and with enforcement. And finally, they added some language that applies to the Administrative Procedures Act to make sure that this aligns with the skill-based amusement games as well. So those were the 4 simple little amendments. And again, I would encourage an aye vote on concurrence.
Is there any discussion on the concurrence request? Seeing none. You are voting on message number 334, concurrent request to House Bill 133. Chief Clerk will call the roll. A majority of elected members is required.
Andrew, Baker, Banks, Bear, Blackburn, excused, Brown, Burkhart, Burt, Clausen, Clifford, Connolly, Crago, Duncan, Eklund, Air, Flitner, Fortner,
Aye.
Gray, Greer, Hallinan, Haroldson, excused, Harshman, excused, Heiner, Henderson, Hunt, Jennings, Kenner, Knapp, Larson Lloyd, Larson Dan, McGuire, Martinez, Nyman, Newsom, Nicholas, Oakley, Obermuller, O'Hearn, Olson, Ottman, Paxton, Provenza, Roscoe, Schwartz, Sherwood, Simpson, Summers, Stith, Stibar, Sweeney, Walters, Washit, excused, Western, Wharf, Williams, Wilson, Winter, Yin, Zawanitzer, Mr. Speaker. Closing vote, are there any changes? Air, aye to no. Knapp, aye to no. Clausen, aye to no. Further changes? Fortner, are you changing your vote? Fortner?
Yes, I am.
Aye to no. Further changes? Closing vote? Brown? Closing vote? The vote is closed. 36 aye, 20 no, 4 excused.
By your vote, you have voted to concur with Senate amendments to House Bill 133. Mr. Majority Floor Leader.
Mr. Speaker Pro Tem, I move that the House resolve itself into committee of the whole.
You've heard the motion. All those in favor say aye. Those opposed? Okay. We'll resolve ourselves as a committee of the whole. Representative Burt.
Committee of the whole, please come to order. Mr. Majority Floor Leader. Mr. Chairman, thank you. And so, ladies and gentlemen, I'm going to right off the bat alter the committee of the whole list. And so the first bill for your consideration will be Senate File 118. And then we'll start down the list as you see it. So 118 is going to be first, and then we're going to roll down the list for a ways, and then we'll do some more changes.
Representative Washit,
Thank you, Mr. Chairman. Point of personal privilege.
proceed.
Thank you, sir. Up in our west gallery, up above us, you all know that we passed out of this house without a dissenting vote, House Bill 111 on organ donation discrimination. And up there is young Mr. Sawyer Stoll and his mom Jessica and the rest of the family. We're celebrating Sawyer's Day. We just signed House Bill 111 into law. Mr. Speaker. Also with him is Mr. Brett Andrews, who's one of our medical students. And he's one of the spokespersons who came on, and his older sister is just an amazing woman with Down syndrome. And he gave tremendous testimony, and he came today for the signing ceremony as well. Brett Andrews.
Thank you for joining us, and please continue to watch us as we do the people's work. Thank you. Chairman Harshman,
Thank you. Privilege of the floor, Mr. Chairman.
proceed, sir.
Yeah, just wanted to add one more note about Brett Andrews up there too. If you get on the YouTube and you search him out, he's a really talented musician as well as one of our WWAMI students. And all these folks, you know, are from Casper, NCHS, Kelly Walsh grads, you know, number one on our license plates, number one on our hearts. So, thanks.
All right, here we go. First bill for your consideration will be, oh, sorry, not too loud. All right, so the first bill for our consideration is Senate File 118. The reading clerk will read the bill.
Senate File 118, sponsored by Appropriations, Federal Emergency COVID-19 Relief Funding, an act relating to emergency expenses of government. Mr. Speaker, your committee number 2 Appropriations, to whom is referred Senate File 118 engrossed Federal Emergency COVID-19 Relief Funding, respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes. Representatives Kenner, Larson Lloyd, Nicholas, Schwartz, Simpson, Stiff, Walters. Representative Nicholas, Chairman.
You have heard the reading of the bill. What is your pleasure? Chairman Nicholas.
Thank you, Mr. Chairman. I move on the committee of whole rise and report. It does so with the recommendation that Senate File 118 do pass, along with the amendment from the Standing Committee Amendment, which is your substitute bill number 1. So I would move that as well and ask for your favorable consideration. So ladies and gentlemen, this should look pretty familiar to you because the last, this is a 20-page bill, but the last 12 pages are what was House Bill 263. So the Senate, they passed a bill, Senate File 118, which was their COVID relief bill, which only addressed the CARES Act dollars that we addressed back in May. We, in our bill that we passed, House Bill 263, we incorporated Senate File 118 into it, and then we address the new dollars from the current act, which is the ARP Act. So we don't have two bills kind of passing each other in the night. This was to expedite this process. So we just took the Senate File 118 and took our bill and incorporated 263 into it. So this is a compendium of those two bills just stuck together. And you may recall in 263, we referenced 118 and said that those funds will be distributed as directed in Senate File 118. What Senate File 118 does now is it takes the first 20 million out of those COVID dollars and pays for or makes those funds available for programs that are already approved by the entities that we created last May, and it went through the process to get approval for those projects. But either they didn't have the funds available or the projects weren't completed. completed. So it funds those projects and allows the governor to proceed with those as soon as this bill is signed into law. It also provides another 18 million for similar COVID relief applications. And those are ones that they were time limited, so they couldn't do the capital construction or some other component of it, so they didn't get their application online. So it makes those funds available immediately as well. So right now, there is funding available now for that 20 million and the $18 billion COVID relief projects. And so once this bill gets passed on both sides, and we reappropriate the dollars that were appropriated back in May to allow those programs to continue with those dollars intact. It also captures the COVID CARES dollars that will come from the FEMA money. And as you may recall that it's anticipated that up to $60 to $80 million we may get back from the monies that have already been appropriated, because we can swap them out for the FEMA dollars, and which will make those dollars again for reappropriation. And so they can reopen up these projects that we did last May. So that's what the 118 does. And then 263 is just tacked onto this. And 263 is basically says anything that was appropriated that is not approved here will be dealt with in a special session, including the ARP dollars. So we've already been that's already passed this side of the body. And so with that, I'd be happy to answer any questions.
You've heard the motion of the standing committee amendment. Are you ready for the question? Question has been called. All those in favor say aye. All opposed, say no. Standing committee amendment number 1 has been adopted. We are back in the bill. Question being called. All those in favor of Chairman Nicholas's motion that when committee of the whole rises to report, it do pass recommendation to bill Senate file number 118 do pass. All those in favor say aye. All those opposed say no. Senate file 118 has passed committee of the whole. The next bill for consideration will be Senate file 78. Reading clerk will read the bill.
Senate File 78, sponsored by Senator Pappas. Real estate appraisers, continuing education, an act relating to real estate appraisers. Mr. Speaker, your committee number 7, corporations, elections, and political subdivisions, to whom is referred Senate File 78 engrossed, real estate appraisers, continuing education, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Blackburn, Clausen, Clifford, Duncan, Air, Hunt, McGuire, Roscoe, Swanitzer. Representative Swanitzer, Chairman.
You have heard the reading of the bill. What is your pleasure, Chairman Swanitzer?
Thank you, Mr. Chairman. I move when the committee of the whole rise to report, it do so with the recommendation that Senate File 78 do pass. There are no standing committee amendments, and I would turn it over to the good chair, Vice Chairwoman of Minerals.
Vice Chair Duncan.
Thank you, Mr. Chairman. So all we're doing in this is we're basically making this conforming with federal regulations, because all of our appraisers must follow government regulations, and those rules change quickly. So if you are an appraiser, you have to make sure that you comply with government-backed loans. And rather than putting in specific dates and hours for our education requirements, we're just making them conform with Fed requirements, and that makes us more flexible and be able to react quickly to those constant changes for Fed requirements in HUD standards. So I encourage your aye vote.
Any other discussion on the bill? Hearing none, question being called. All those in favor of Vice Chairman Duncan's motion that when committee of the whole rises to report, to do so with the recommendation that Senate file number 78 do pass. All those in favor say aye. All those opposed say no. Senate file 78 has been passed, committee of the whole. Next bill for consideration is Senate file 75. The reading clerk will read the bill.
Senate File 75, sponsored by Senator Landon. Protective orders, amendments, an act relating to the courts. Mr. Speaker, your committee number 1, Judiciary, to whom is referred Senate File 75 engrossed, protective orders, amendments. Respectful report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Craigo, Larson Dan, Oakley, Olson, Rodriguez Williams, Washit, Yin, Swanatzer. Excused, Representative Provenza. Representative Olson, Chairman.
You've heard the reading of the bill. What is your pleasure? Chairman Olson.
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report that it do so with the recommendation that Senate File 75 do pass. I further amend the adoption or further move the adoption of the Standing Committee Amendment number 1. I'll explain the Standing Committee Amendment and then turn over the bill. The Standing Committee Amendment is really quite simple. All it does is make the bill effective immediately.
There we go. You've heard motion on the Standing Committee Amendment. Are you ready for question? Question? Did you want to, Representative Brown? Okay. Question been called. All those in favor say aye. All opposed say no. It has been passed. Standing Committee Amendment number 1 has been adopted. We are back on the bill.
Yeah.
Chairman Olson.
Thank you, Mr. Chairman. And I will turn over the explanation of this bill to the good representative from Lucky House District number 9.
Representative Brown.
Thank you, Mr. Chairman. Ladies and gentlemen, this is a continuation of a bill of a bill from about 4 years ago, where we did some enhanced penalties for stalking and the such. And ultimately, what happened is we had a case after that happened where we had a situation where somebody was found to potentially be in violation of the felony version of our stalking statutes. And unfortunately, what had happened is there was this difference between a court order and a stipulated order. And the difference between those two is, you know, in the eyes of the court system, there's really not much of a difference. But unfortunately, what happened is they had this stipulated agreement. They didn't have a stipulated agreement. But I'm going to back up here. I'm going to just come back down and level this out here. What we're trying to do with this particular bill is say that stipulated agreements, when they're in, when it's in situations with stalking, that a stipulated agreement has the same volume and the same basis in law as what a court order has. And what has happened is this has been an ambiguity in current state law. And unfortunately, this has allowed certain cases to not be adjudicated, in my opinion, correctly. Now, that's a certain opinion. That's for the judicial branch to argue. But Mr. Chairman, what we're doing here is this allows, it came to my attention here. I'm just going to read from my script. It came to my attention that inconsistencies exist in our state about how protection orders are viewed in our courts. Several years ago, I did not know a lot of how to help our stalking laws and how to protect them, but with a lot of help from legal friends of mine, I learned that these protection orders, and specifically stalking, sexual assault, and domestic violence protection orders, must be viewed and treated like all valid orders. Senate File 75 does two things. First, it allows parties to protection orders to make knowing and voluntary stipulations to the order and allow the court to have jurisdiction. I think those are the two biggest pieces of this is knowing and voluntary. These stipulated agreements, everybody knows what they're doing and they're signing on to them. This is not something being forced on anybody. They are knowing and voluntarily signing into these. It saves the court time to do this. It allows victims to not have to face their stalker and abuser at the height of a crisis. And it allows respondents to not have this impact other open criminal charges at the time of the stipulation. Second, it ensures that this order is valid and enforceable just like any other stipulated order in civil or criminal court. And Mr. Chairman, I see that we have one of our good resident attorneys in the House that is already just chomping at the bit to get up here and have a good discussion with us. So I'm going to turn it over for questions and let the debate begin.
Representative Steth.
Mr. Chairman, thank you. Members, folks, please just vote no on this. Okay, this is like a really bad idea. This is like bad idea genes. This is really bad. This bill is good if you're really guilty. Okay, so this bill might protect guilty people and make guilty people have less hassle in the courtroom. So wonderful, right? I'm really guilty and I don't feel like going to court. Wonderful, right? But if you're innocent, this bill is bad news, and in the following way. The bill actually arose out of my county. It was actually a case I was involved in. My client, completely law-abiding, 62 years old, no criminal history, keeps an immaculate lawn. He's in his backyard a lot. Okay. His neighbor didn't like it that he was in his backyard all the time and thought that he was harassing. And so the neighbor who believed that my client was stalking him because he was in his backyard working on his roses, files a civil petition for an stalking order of protection. So it's a civil case, right? Just between two people. The government's not yet involved. Frankly, it's just two people, two neighbors who don't like each other. Go to court. And if this bill becomes law, then the judge will say, hey, we don't have to have a hearing. We're not going to say that you're a bad person. We're just going to enter a stalking order of protection against you, telling you not to harass your neighbor anymore. And you go there, and this hearing happens really quick. It happens within 10 days, 2 weeks. You may not have a lawyer. You just show up and you say, well, I'm not bothering my neighbor. I don't mind. And so you agree to this order of protection being entered against you that says don't harass your neighbor. And you think, well, fine. Well, what happens next? Your neighbor still hates you, right? And now, if your neighbor thinks you have violated this order, and this is where it really bites, if your neighbor thinks that you have violated this order that you've agreed to, you can now be charged with a felony, because it is a felony to violate a stalking order of protection. So now you get charged with a felony, and now you have to hire a lawyer, and your lawyer goes to court, and your lawyer says, hey, there was never a factual finding that my client ever did anything wrong, ever. Okay, under current law, you get the case dismissed because your client, in fact, did nothing wrong. But if you pass this bill, then someone who agrees to the stalking order of protection, and if your neighbor who doesn't like you thinks that you violated it, you get charged with a felony. In this particular case, the homeowner, the accused, had some cameras on the outside of his house for years. Neighbor moves in next door, doesn't like the cameras, goes to court. Neighbor says, okay, fine, I won't have my cameras surveilling your property, fine. Neighbor says, wait a second, I think your camera is surveilling my driveway, this strip of concrete. And indeed, video surveillance, there it was, strip of concrete leading out to the sidewalk was shown on the homeowner's camera. That's a violation of that particular order. So bam, now you're charged with a felony. So this bill is great if you're guilty. It's really a bad idea if you're innocent. So vote no, please.
Representative Oakley.
Thank you, Mr. Chair. So that was a really lengthy scenario that made it sound that there's, bad and evil and dire consequences to this. And I really strongly disagree with that. So it all starts out, this is actually something that has been done for quite some time. As they said, as happens, a case was brought in front of a judge and they said, it needs to be authority in law for you to stipulate to a protection order. That's all that this is asking for. And that's really important, that I think belies the whole point that the last speaker brought up, which is the word stipulation. You enter into this on your own. So all the consequences he talked about don't happen if you don't choose to enter into this. So what it allows is for a defendant or a respondent to say, I will allow for a protection order to be entered against me without findings. And this is why it's important that it's there for both, I would say, let's say a domestic violence case. Because let's say if there's charges pending against that defendant, and they can't just say, and by the way, it has to be knowing and voluntary. So both the defendant knowing and voluntary, and the judges makes that finding that it was knowing and voluntary on the respondent's part. So it doesn't just happen to you. But if you have charges against you and they can't just stipulate to a protection order, then the judge has to make findings. Well, that puts us in a quagmire, because then the defendant, they would have to be putting this evidence that could be used against them at trial in 2 months. You would actually have to have those findings and start litigating that. Could be 2 or 3 days after
let's say a domestic violence event happened, that affects the defendant's rights. And if you don't have that hearing, then you can't order the protection order for the woman, and that might be, or it might not be a woman. It just happens to be 90% of the time. But then you can't have a protection order in place, which puts an extra layer of protection for them when things have escalated. A lot of times in a domestic violence situation, right around the time it's happening is the most dangerous. So what this does is allow both parties to step away, say, okay, I'll agree that there's a protection order in place, but no findings have been made. So let's say he ends up being acquitted, they could take that, no findings have been made, could get rid of the protection order. But without it, it doesn't give us the opportunity, it doesn't give the people the opportunity to have a protection order at all, which isn't fair to victims. And having findings on the record before the case has been litigated isn't fair to the respondent or defendant. So this is the solution that works, that makes it, I'm trying to get the word, a situation that both can not affect, that can protect the victim and not affect the defendant's rights. So I think it's a really important tool. And again, it is something that has been done, and then it just brought up, well, maybe there's not authority in the law for that. So this creates that authority. So against the amendment and for the bill.
Chairman Olson.
For the bill.
Yeah, thank you, Mr. Chairman. Just kind of want to tag on to because I think the last speaker really hit the nail on the head when the good prosecutor brought up domestic violence. And from my perspective, I don't do work in this area anymore, but my law firm does work in the family realm. And there's two things that I actually think the stipulated order provide huge benefits to the respondent. So whether you're guilty or not, I know that was brought up. This is good, Bill, if you're innocent, bad if you're guilty. I don't know about that. What I know is that if you're the respondent, there's a lot of benefits to this. And number one, gun rights. Okay, so under a protection order, if you can get a stipulated protective order without a finding of domestic violence, you can still possess a firearm. So that's huge. So a lot of individuals in Wyoming will strive to get that stipulation so they don't get those facts and findings entered during an order and then lose their firearm during the protection order. So that's huge. Number two is what was touched on with what happens when you have a finding of domestic violence. So if you have to go to the hearing and you have that finding, those findings of fact, they can affect a criminal matter, but it can also affect a family matter. So it's an automatic presumption on custody issues, and you have to overcome that presumption on custody issues. So I think from the respondent's perspective, I don't think this is one-sided either way. There's a lot of reasons why you as a respondent who may be addressing the protection order, you may want to stipulate to the protection order for a lot of reasons, whether that's gun rights, criminal custody matters, or future criminal matters. So I wouldn't say it's one-sided. I'd say the other piece to it is in the language of the stipulation. The stipulation has to be knowing and voluntarily entered. So what that means is both parties read what they were entering into. They signed their names to the paper, and there's one more step, and this is key, especially if you're a non-lawyer, because you may not have been through this process just to see the next step. Signed by a judge. Stipulated order goes in front of a judge. Judge reviews it. Judge thinks there's not something quite right here, could order a hearing, or could just sign off on it. So that's the last step in the process too. Just know that the stipulated order goes in front of the judge. So on for the bill. Thank you.
Madam Minority Floor Leader.
Thank you, Mr. Chairman. And I have a question, honestly, for the good attorney from the southwest portion of the state who set out a scenario for us. But I'm curious about both the scenario and kind of this situation moving through a process. And the process often involves first a temporary restraining order. And a temporary restraining order, but I'd be concerned as well. A temporary restraining order can be done by one party, ex parte, all of the following. What's going on and what I see with this bill is when both parties agree and it is not mandatory. And so it is a choice with both of the parties to move forward a situation that they agree to, and then a judge signs off on it. So again, it's not that TRO, but instead it is a mediated agreement signed off on. So I often agree with him, but right now I'm a bit confused about that scenario and honestly what I think typically happens. Thanks.
Representative Jennings.
Thank you, Mr. Chairman. So just in full disclosure, I'm not a lawyer and I don't play one on TV. And but I get pretty concerned when I hear things like that we're going to an order pursuant to this section without a hearing, factual finding, or admission. And I think that kind of flies in the face of what we think of for due process for Americans. And so with that, I'll listen more to the debate, but this is very troubling to me that I want due process.
Chairman Greer.
Thank you, Mr. Chairman. I'm a recovering attorney, and I'm as confused as anybody. I'm wearing a blue striped shirt, not a blue shirt, so I think that's part trustworthiness. So I think the comments that were made that this, if you're guilty, this is a good thing. If you're innocent, this isn't so good. And I agree with those comments. I look at that way. Who would stipulate if they were innocent? They're having a dispute. You just can't get along and I say, okay, look, rather than go through all this hassle, I'll stipulate, I'll stay away from you. We'll leave each other alone. Okay, simple, innocent, not a problem with that. The people that would utilize this are those that are trying to hide domestic abuse, those that are trying to play games with it. And I think this is a real dangerous path we go down. These protection orders, okay, are a strict restriction on our fundamental rights of our own freedom. The right to see our children, right to access certain locations within our community, right to visit friends, complete restrictions. They should not be without due process of law. And so we're coming in and just saying, hey, we'll encourage people to stipulate to it because it's easy. That's bad policy. Really is. And I don't understand the arguments for this bill. Completely understand the argument against it. But no.
Representative Stiff.
Mr. Chairman, to respond to one question that was raised or a statement that was made, there's nothing in this bill that preserves your gun rights after you voluntarily sign one of these orders or agree to it. So if you agree to one of these orders without any factual basis that you've stalked anybody or that you've engaged in any conduct that would give rise to an order of protection, your gun rights are still affected by this because this bill says that it has this admission that you've made without any factual finding or hearing has the same effect as though you were found to have been harassing, engaging in a course of conduct to stalk the other person. So there's no gun exception here. This is not a great deal for you. If you're innocent, you are compromising your gun rights probably without realizing that you're doing that. So there's that. And then with respect to the question from the representative from District 37, I believe, 13, I apologize, 13. Right now in the law, you can reach a stipulation. You can stipulate to facts sufficient to enter an order if you want to, if you're the respondent in the civil petition. You can do that already, but you would have to agree to facts that actually give a basis to it. And it's just part of our justice system that we want our court proceedings to be real. We want them to be genuine. We want it to mean something. That is that there really is a factual basis. We don't let people plead guilty to crimes they've not committed. If you plead guilty to a crime, you have to make a factual basis to the judge that you actually did commit each of the elements of the offense. before the judge can even accept your guilty plea in a criminal case. So why in a civil case here, we would say, we're just going to enter this order, even though there's no factual basis to believe that any of it's true, just seems to run against the grain of our system of justice. So vote no.
Representative Brown.
Thank you, Mr. Chairman. So I think this conversation, and again, well, I guess we're doing disclosures here. I'm not a lawyer either, but I stayed at a semi-fancy hotel just the other night. So we'll I think one of the biggest things that we have to look at here is what was just stated, is that this is potentially going to violate your gun rights, potentially going to violate your ability to have custody. But one of the biggest things that I think is really important, ladies and gentlemen, is this stipulation is entered into voluntarily and knowingly. You have the chance to read this agreement. And if this agreement says there was no finding of domestic violence, that's not an admission of guilt. If it says there is a finding of domestic violence and you sign off on that, I don't know if that's an admission of guilt, but I certainly don't think I would be signing that. That's a knowingly, that's me knowing what I'm signing and putting my name onto. I read things. And I think that's what we're saying here, is we're trying to cut down on this process of having to go in front of the judge on everything and having these hearings and all this. But we're asking these people to have these conversations with each other. And then it goes. I heard a conversation that this is without due process. I'm sorry, but that's just not the case. This is going in front of a judge. You're just entering into an agreement that says, hey, look, we can't get along. We both agree to stay away from each other, or you agree to stay away from me. So let me put another perspective in here for you. Husband and wife are at home. Husband decides whatever happens, he gets aggressive, scares the wife. She says, I want to separate, and goes through this process and says, I want to stipulate an agreement. Currently, as it stands, if he signs that and says, yep, I'll stay away from you, he can violate that as many times as he wants and cannot be charged with anything. So what good is a stipulated agreement? If he's going to continue to violate that process, there's no sense in actually doing a stipulated agreement. If they're allowed to violate that. And the other thing about this is the most important piece, you don't have to stipulate. You don't have to enter into this agreement. This is just saying that if you do, you're recognizing that what that agreement says, that order says, and when it's signed off by that judge, it has the full force and effect of law. That's what we're doing with this. Thank you, Mr. Chairman.
Madam Chairman Wilson.
Thank you, Mr. Chairman. I'm not an attorney either, although I did take 2 law classes in grad school. But the discussion that I'm hearing, it sounds like we're suggesting that this person who is stipulating has the benefit of the incisive legal advice of members of this chamber. But I know we have cut a lot of legal aid, a lot of pro bono services. It seems to me that there are a lot of people out there whose a lawyer assistant might show up once every 2 weeks. And, there's that old saying about the person who acts as his own lawyer has a fool for a client. And I'm a little concerned that we're expecting people to have read things and understood what they signed. And in fact, they might not have legal representation, and then they're really in trouble. So I'm starting to lean toward a no on this.
Representative Oakley.
Thank you, Mr. Chair. So I'll try one more time. We've talked a lot about due process. And I guess what I think is key here is that we're talking about closing a loophole so that we can move forward without affecting a defendant's rights when it comes to criminal prosecution. So if a person goes forward and is convicted of domestic violence under federal law, they lose their gun rights permanently. This is a solution so that a judge does not have to make findings about fact, as the original opposer of the bill said they can stipulate to facts sufficient. If the facts are sufficient, the facts have to be discussed. If the facts are discussed, that affects that person's due process. When we're talking about due process, this gives the ability to protect that respondent's rights. And that is basically what this loophole or whatever that is closed. And if not, if we're not talking, as the first example was a civil suit, then, first of all, then you're talking about less significant rights. But again, they'd still go in front of a judge. The idea that that there aren't due process rights when you stipulate to something just isn't the case. The judge tells them, even if they are pro se, even if they're unrepresented, they don't have to be, but if they were, the judge goes through what restrictions that is. And they have to knowingly and voluntarily stipulate to it. So, I don't think there's a due process on that issue, and we're solving an issue that would be a much bigger due process right for that respondent by being able to enter into it without going into the facts of the case, let's say at three days after the incident. So this can help the due process rights for that respondent. So for the bill.
Representative Craigo.
Thank you, Mr. Chairman. Just following up a few comments from our good prosecutor in the body. I think really as we look at this bill, what it does, and as she explained, it closes a loophole. And we're here today, we get to make a policy choice. We can either leave that loophole in, which protects one party in this proceeding, or we can close the loophole and protect the other party in the proceeding. And I would ask you, as we sit here today, to think about the victims, which is often this is what this bill is talking about. It's a closing a loophole for that victim. On in favor of the bill.
Is there any further discussion on the bill? Question being called. All those in favor of Chairman Olson's motion that when the committee of the whole rises to report, to do so with the recommendation that bill number 75 do pass. All those in favor say aye. All those opposed say no. Chairs in doubt. All those in favor, please stand. All right, all those opposed? With the 29 aye and 23 no, Senate File 75 has passed committee of the whole. Next bill for consideration will be Senate File 4. The reading clerk will read the bill.
Senate File 4, sponsored by Transportation, Airport Districts, an act relating to aeronautics. Mr. Speaker, your committee number 8, Transportation, Highway, and Military Affairs, to whom was referred Senate File 4, engrossed, Airport Districts, respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Burkhart, Henderson, McGuire, Obermueller, O'Hearn. Noes, Representatives Baker, Brown, Burt, Stibar. Representative Burkhart, Chairman.
You ever heard the reading of the bill? What is your pleasure? Vice Chairman McGuire. I apologize. Chairman Burkhart.
Thank you, Mr. Chairman. I move when the committee of the whole rise to report, to do so with the recommendation that Senate File 4 do pass. I further move the adoption of the standing committee amendment and turn the explanation of the bill and the standing committee amendment over to the good representative from the center of the state.
You've heard the motion, the standing committee amendment. All right. No. I apologize, Vice Chairman McGuire.
Thank you, Mr. Chairman. Members of the body, I'm reminded of the story of the airline pilot. Now, it could be a male or a female airline pilot who was out on a date, and he turned to his partner and said, "Hey, enough about me. Let's talk about airplanes." Well, I say enough of criminal law. Let's talk about something that's really interesting, airports. So full disclosure, currently I'm the president of the airport board in Casper. I receive no financial benefit from that position. I have discussed it with LSO. At this time, the Casper Airport is one of the 3 airports in Wyoming that is financially self-sufficient, so would not benefit from this bill. So I don't think that there is a conflict with me presenting the bill or voting on it. So moving forward, what this is this is a bill to authorize counties and municipalities to establish an airport district, to specify the duties and powers of that airport district, authorize assessments, borrowing money, distribution, and distribution of fuel tax with regard to that airport. So I'll just briefly run you through. Primarily, the body that will be responsible for the creation or establishment of an airport district is the local county commission or the county commissioners. Airport districts will be composed of lands within a county or municipality that plan to participate in that district. All the parties to that must agree to form a district, and they would set forth a resolution. The resolution would provide a plan to transfer to the district the responsibilities for operation of the airport or multiple airports. The Board of County Commissioners will submit the proposed boundaries of that airport district to the county assessor and the Department of Revenue for review of any conflict, overlap, gaps, or other boundary issues. Moving on, land may be added or subtracted from a district. There will be establishment of a governing board. Typically, an airport board calls for 9 members for a term of 3 years. Moving on to page number 6, there is no power or authority for eminent domain, if that comes up in this question, or excuse me, with this bill. Moving to page 7, an airport district may be dissolved by resolution. Going to page number 8, taxation, I'd like to hold on that for a moment and come back to it. Typically, when an election comes up for an airport district, and that would be the subject of Standing Committee Amendment number 1, which I would ask for your favorable consideration. The amendment was to make that eligible, or the item would be only on a general election. It wouldn't be during a special election or primary. So at this time, Mr. Chairman, I would move Standing Committee Amendment number 1 to Senate File number 4 and ask for your favorable consideration.
You've heard the motion of the standing committee amendment. Are you ready for the question? Question has been called. All those in favor, say aye. All those opposed, say no. The standing committee amendment number 1 has adopted.
Thank you, Mr. Chairman.
Back on the bill.
So moving on, it allows the airport governing body to issue bonds or notes, typically for construction. It also allows them to borrow money. And then if you go to page 12 and beyond, those are conforming amendments. So if I may, we'll turn back to the taxation because that's really the elephant in the room for this. So to set the table a little bit, right now there are approximately 40 public use airports in the state of Wyoming. 3 of those are financially self-sufficient, and that would be Cheyenne, Casper, and Jackson. And the reason being is we have sufficient commercial air travel. We have sufficient land. We have, for example, my airport in Casper. We have an industrial park. We have an ag section. So between all those revenue sources, we're able to pay our own way. We don't go to the county. We don't go to anybody to ask for money. And we operate in a financially independent manner. And we report to the county. We submit our financials and everything audited. And that is how our airport moves forward. Same thing with the airport in the northwest corner of the state. Again, they have commercial air travel that allows them to be financially independent. When you go to the other smaller rural airports, many of which are in your districts, unfortunately, they don't have the revenue sources to allow them to operate in an independent manner. So either the municipality or the county subsidizes those airports. There's also federal grant funds. When I buy a gallon of aviation fuel, I pay pretty substantial amount of tax for that fuel. And then what the FAA does is they allow you to apply for a grant to receive those funds back. And it's not always on a one-to-one basis. It's not how much fuel was sold at that airport. You have to put in a proposal, you have to show a need, and then you apply for those grant funds. They come back to the airport. So the issue is, and the reason for this bill is a lot of our small airports are struggling now. There are enhanced requirements. For example, after the 9/11 attacks, the administration that deals with aviation went around and said, everybody, you've got to put a big fence around the airport. And it was not a cheap fence. It wasn't a 3-wire barbed wire fence. It was a tall fence. And for example, at our airport, in order to prevent animals from getting anywhere near the runway, we had to bury 4 to 6 feet of wire underneath the fence so that a fox or something like that wouldn't dig under and get out and potentially run across the runway. So these small airports struggle with these requirements. And right now the cities and the counties are subsidizing them. But as our revenues shrink, now these airports are looking for an alternate way to fund the airport. So that's why the proposal to allow them to put forward an airport district. The issue with airport districts, and again, it's the elephant in the room, is you're asking your residents to tax themselves to support the airport. And this bill proposes a 3 mil, which a mil is $1 per thousand of assessed value. And I think it's important to remember that when you look at your statement, for example, for your house or whatever, there's 2 different values. And one is the assessed value. That's very different than the market value. For example, on my house, the assessed value is about 1/3 of what the market value would be. And that's what they charge the mills against, is the assessed value. So it's not the market value, it's the assessed value. So what this does is it allows the airport to go to the county commission to propose a plan. And then at that point, the county commission will start drawing maps. And the big question is, who's going to be included in that district and how much are they going to pay? And again, we have mineral producers. They are assessed at full value for their land. And so oftentimes they don't want to be in a district. And there are examples. For example, there's one in the area where the river is very green, where there are trona mines, and they had a solid waste. They wanted to put in a district for solid waste. And so they cut those trona mines out because they don't use the solid waste facilities. They don't participate in it. And obviously their assessed value is way higher than the people who are using that particular service. So they cut them out. And that's what the county commission can do. The county commission can accept feedback from all the parties that are involved and hopefully come up with a map that's fair to all, and hopefully will include those who want to participate, because there are some companies that find it extraordinarily valuable to be able to have these private aircraft come in, have business aircraft come in. We heard about air ambulance. Air ambulance is not just helicopters. Air ambulance is very often fixed wing aircraft. And in order to get those air ambulance people in, especially during the snowstorm that we just had, somebody's got to go out and clear snow off the runway. Somebody's got to make sure the instrument approach is up and running. Somebody's got to have fuel there. So all these services are expenses. And unfortunately, the amount that these smaller airports are receiving back from the grant funds are not covering their everyday expenses. So that's the purpose of them being able to go out and ask for a a taxing district. So the plan would be to go forward, put out a plan, hopefully that's acceptable to the parties, publicize it, let the parties weigh in. At that point, the county commission would decide on the borders of the tax district and submit it again to the county assessor and to the Department of Revenue. If they buy off on it and they think that it's fair, then it can go to the general election and the people who are in that district can vote on it. And again, going back to our mineral holders, again, the issue is, for example, if it's the oil field that has Salton Creek in it, well, how many people do they have there that could vote for or against it compared to the entire population of my town, Casper? So that's where the inequity comes, and hopefully the county commissioners would be able to bring that forward in a fair and equitable manner and create a map that would be fair for everyone. So with that, I would stand for questions.
Chairman Burkhart.
Thank you, Mr. Chairman. At this time, I'll move Committee of the Whole Amendment number 1. I have 2. I'll move only number 1 at this time. And that is the technical correction recommended to us by staff. Line 11 or page 11, line 5, delete C and insert D is the only change there. And if there's no discussion, I call for the question on that amendment.
All right, we are in Committee of the Whole Amendment number 1. All those in favor of Committee of the Whole Amendment number 1, say aye.
Aye.
Opposed, no. The amendment has been adopted. Chairman Burkhart.
Thank you, Mr. Chairman. I will move Committee of the Whole Amendment number 2 to Senate File 4. Ask for your favorable consideration. Ladies and gentlemen, this is something that's bothered me for quite a while. Most of you don't realize we have 800 plus special districts in the state. And when they set these up, and they're for any number of things, they look at where they can get the most bang for the buck, so to speak, and they incorporate a lot of land, a lot of that from people who cannot vote, our industrial producers, ag producers, and they just bring them in order to get the tax revenue. We don't have any corporations who can vote. So they bring those in and then tell all the people in the local community, vote yes or no. So the people who really pay the majority of that money do not get to vote on it. So this thing about, well, the people get to put a tax on themselves is true to a point, but not the whole story. What this amendment does is says that agriculture, commercial, and industrial land are excluded from this district. This district only applies to the land owned by those people who can vote for or against the district. And that's the nature of the amendment. So that we aren't taxing natural gas producers. We are not taxing ranches or anything else to pay for this. Now, I understand, yeah, they will probably use them, but the county commissioners get to establish the boundaries. And I've seen them go into other counties to actually take in industrial producers, knowing that they will pay the majority of the tax on these levies and that. And while 3 mills might not sound like much on assessed value on a home, 3 mills on a several $million oil field is a lot of money. So with that, I'd stand for questions, comments, whatever.
Vice Chairman McGuire.
Thank you, Mr. Chairman. So just a gentle pushback. I like to think of those being the old days when we had county commissioners that were maybe looking for the big, deep pockets. And I like to think that our current county commissioners would be trying to create a very fair and equitable manner to implement these districts. Also on page 9, there is a small sunset in there. This particular district, the way that this bill is written, is these special districts would expire every 10 years and they would have to be reapproved by the electorate. So in order to address that problem of, yes, there are some special districts out there that nobody even knows about, nobody knows where they are, or has seen the text of them for years. There is that provision in there, so it would be every 10 years. And also I would, ask you again, this is not all over. This is going to be selected small airports that are going to go out, allow them to try and make their best case. And if you take out, for example, commercial users, well, that would include the big box stores that pay virtually no tax anyway, and certainly use our airports and use our infrastructure. So I would encourage you to vote against the amendment. And again, let these small airports, let them make their best case, and it will, rise or fall based on their best case that they make, not only to the commission, county commissioners, but also ultimately to the electorate. So thank you, Mr. Chairman.
Majority Floor Leader Summers.
Mr. Chairman, thank you. On and against the amendment. And I've not been around a lot of airports, but I know at our airport, kind of the land surrounding, and I served on P&Z for 9 years, and the land surrounding the airport, primarily, it's not residential because you don't want to have houses there. What you do is you put your industrial and your commercial zone property around the airport. So in fact, those zonings benefit from this because you have an attraction of business to an area. They use the hub of the airport. And I just think, of course, we in ag don't like to be taxed for anything, but so maybe I'm for that. But on the side of the industrial and commercial, certainly, I think it benefits them to have this designation around those airports.
Representative Brown.
Thank you, Mr. Chairman. On and for the amendment, ladies and gentlemen, and for a very specific reason. We're asking yet again our extractive industries, the people who pay the majority of our bills, to pay yet another bill. That's what we're doing here. This amendment says, hey, look, if you're not eligible to represent your interest in this, so let's think about this. Let's say you have an oil and gas field somewhere around your airport and it's owned by an individual. They don't get to go vote in this election. Maybe they don't even live in that area, but they're sure as heck going to be paying the taxes for that airport district because they're the ones that pay the fees for almost everything we do. This is another step in the direction of asking the same people that pay all of our other bills to pick up the tab on another bill. This amendment fixes that and says, hey, look, if you want an airport district, you're going to have to pay for it. And I want to hear, I want to make sure it's heard clearly too, that yeah, we're talking about the smaller airports, but ladies and gentlemen, this is not pushed aside only for small district or for small airports. Every airport can go in and ask for this. So I'm 100% in favor of this amendment. This amendment says, if you have a vested interest in this and you want an airport, you're going to pony up and pay for it. We're not going to ask somebody else to do it for you. On in favor.
Representative Newsom.
Thank you, Mr. Chairman. On and against this amendment, I could maybe get behind it if it were just agricultural and industrial. But when you exempt commercial, a lot of our downtowns, I know in my community in Cody, our downtown is zoned commercial, and our downtown benefits greatly from our airport. Our airport is one of those which sadly is not self-sustaining, and we do ask for money from the county and the city, and they provide that. However, as their budgets become tighter and tighter, it becomes more and more difficult for them to contribute to our airport. Our airport board also, we subsidize airlines to serve us. And I am one of those, our family is one of those who for decades has written checks to subsidize airlines coming in to our community. And I find it very important as a commercial landowner. I would say that commercial business, Main Street, should contribute to this. So exempting them, I don't think is acceptable. And I also take note of the good representative from Natrona County saying that the airport district, as they create those boundaries, they can include or not include specific lands. So on and against the amendment, on and for the bill.
Representative Yun.
Thank you, Mr. Chairman. So members, ultimately this removes local control, right? So you're telling me that the county commissioners aren't the best to decide what should and shouldn't be included in the airport district. I think we all see the airport as a good economic development driver, right? And who benefits from economic development than the ones that that drive our economy, and that includes the commercial and industrial for that matter. Just because oil and gas may not use the airport enough, there's plenty of industries that use an airport a lot. So I would ask you that I think the county commissioners in your specific locations are the best ones to know which part of what the boundaries of the airport district should look like. So if they don't think that they can get it through voters to put another tax on oil and gas, they're not going to include oil and gas in their airport district, because that doesn't make sense, because they'll just get the airport district voted down. So again, I think this removes local control, and I think that your county commissioners are best at determining where the boundaries of the airport district is, and I would ask you to vote against the amendment. Thank you, Mr. Chairman.
Representative Nyman.
Thank you, Mr. Chairman. I'm dealing with this right now in a forum. I actually was on the airport board, chairman of the airport board, when we first built our airport in Hewlett. I actually took part of our ranch to build the airport. And so now I'm also in the middle of another deal. They're kind of having to deal with it is, and when you're talking about special districts and some of the implications that go with them, we're in the process of trying to decide up in our part of the country whether we're going to do a solid waste disposal district in order to finance a landfill. And one of the main issues that we dealt with was the fact that industry and corporations that don't have a large voice in the ability to vote on whether or not they want to be part of that district or they're incorporated into it are going to be paying the lion's share of the cost of that district. They said because the municipalities, the people that really would like to see this happen, will far, far outvote them. But they are far, far and away the biggest providers for the dollars that they're going to be receiving into the district. And so there's while I would love to see, development, and I know a lot of these towns, and we have one, we have a small, what's it called? It's a non-controlled airport up there. The issue that we're going to see is how do they determine that? Am I going to have to try to opt out of having my property assessed at a higher evaluation in order to fulfill this airport need because I'm adjacent to it? And there's no way that I'm going to be able to outvote the entire town or several municipalities around there because of that. And so I struggle with the idea that, hey, guess what? We need this. We're just gonna do this, and sorry, but you're just gonna have to pay this because you may or may not ever use this. And so if there was a way you could do this, folks, is there a way that you could opt in? I want to use the airport. I want to do this. It's the same way with the waste district. If you're going to use the waste district, then opt in. If you're not going to use it, then you'll pay a higher fee to use that waste district. That's your choice. But give those folks the opportunity to be able to say whether or not they want to be in this. So for the amendment.
All right, we are still on Committee of the Whole, Amendment number 2 for Senate File number 4. Chairman Eklund.
Thank you, Mr. Chairman. So this continues a conversation that we've had for several years, and I think we need to decide on a policy decision as to whether we let. So for a while, the state was subsidizing airports, significant subsidy. And the reason we did it is we didn't believe we could have economic development in certain regions without airlines. And it affected every industry. I think especially our mineral industry is what we were most concerned with. I think that we have to allow the county commissioners to do what they think is best and give them back the local control. So I would be against this amendment. And the main reason being that the state does not have the money to subsidize airports anymore. These airport districts need to be able to set up in a sustainable way. So I'm in favor of the bill and against the amendment.
Representative McGuire.
Thank you, Mr. Chairman. So again, I would encourage you to vote against the amendment and allow the local areas to make those decisions. And to our good member from the Bear Lodge country, you know, we owe his family a debt of gratitude. That airport that he's talking about, that was the last public use airport built in the United States of America in the last 8 years. And it was due primarily to the generosity of his family, donating the land and helping financially and everything to bring that forward. So, but I'd also point out that that particular one, there won't be any extractive industries that will be assessed if that airport should ask for a district, because that's not an industry that's in that area. Now, certainly agriculture is, and you know, there's just no good way to get around it. Your county commissioners who are elected officials, hopefully they will be responsive, and hopefully they will create a fair and equitable map that will allow all parties to participate and to, you know, be assessed in a fair and equitable manner. So thank you, Mr. Chairman.
Chairman Burkhart.
Thank you, Mr. Chairman. Just to address a number of issues. One is, you know, if you trust your county commissioners, fine. If you don't, fine. You know, you're at their mercy. I was involved in setting up a special district that was ultimately decided not to. And in the first meeting, the first thing that was said was, we need to get these 3 companies inside the district because they're the largest taxpayers in the county. Had nothing to do with whether the service was for them or not. It had to do with getting money out of them. And while the state might not be able to subsidize airports anymore, I would offer that neither can our industrial companies and corporations in the state afford to subsidize everything that they're being asked to subsidize. And that this is just one item. It happens to be airports this time. It could be any number of special districts. Oh, I don't know, sewage districts, any number of districts and that. So if you don't like a commercial property in there, there's already a second amendment, second reading amendment being drafted to remove commercial properties. And you'll have the opportunity to vote on that. I ask you to vote aye on the amendment and let the people who don't get to vote out of being included. It's the old one person, one vote idea, and people are not included in the vote, but they're included in the district. And I just don't think that's fair. So with that, and seeing no one else at the mic, I'll call for the question on the amendment.
All those in favor of the committee of the whole, amendment number 2, say aye. Opposed, no. Chairs in doubt. Sorry, all those in favor, please stand. Thank you. All opposed, please stand. With a vote of 28-26, the amendment is adopted. Is there any other discussion on the bill? Question being called. All those in favor of Chairman Burkhart's, oh, sorry, Chairman Gray.
Thank you, Mr. Chairman. So I'd urge a no vote on this bill. There are already abilities for a lot of different revenue flows into these airports, including distributions from localities. And I would pose to you, this is just another example. I mean, I got to go through, I think we're up to number 8 or 9 now, of where something that is supposed to or traditionally been covered by the general property tax revenues allocated by the legislature is now we're creating a carve out where now they can increase taxes on the citizens within a county, 3 property tax mills. And we're not pulling back any of the state funds that are currently used to support these counties. And so where is the back and forth here that should be considered in these pieces of legislation? Because everything, it's just, we're going to grant more authority for taxation from the counties. We're going to give the legislature is going to give the counties more money. But when this authority is granted, there's no discussion about pulling anything back. So I think they already have the ability to receive federal funds. There's a variety of programs. They receive their tenant fees. Granted, our federal government fiscal position is rapidly deteriorating, but those programs are there. There's stimulus dollars flowing all over the place. And I think it's inappropriate to be taxing our people an extra 3 mills for this sort of activity, taxing the people of Wyoming. The other thing I'd say too is I encourage you to look at the bill. And we got an email today. I think it's pretty clear that in the supposedly self-sufficient airports, that over time, this is something they're going to look at doing in areas that are supposedly self-sufficient currently. And the bill definitely allows for that. And I don't know how you'd write that out. So I just think this is unnecessary. We don't need more taxation. I haven't really heard any example of why this is necessary. Thank you.
Representative Banks.
Mr. Chairman, I would push back a little bit on that and remind you that we are not passing a tax with this bill. What we are doing is putting the authority back to the government closest to the people to pass this tax if they so choose. It comes up to the commissioners and the local municipalities to decide if this is something they want to pursue, and then convince the taxpayers in that district to vote for it if that's what they so choose. The airports are such a critical part of our economic development structure. And as we look more and more at how we're going to diversify our economy, we really need those airports. They're critical to what we do. This is just another tool in that toolbox for those local economies. It's very similar to the bill we passed yesterday for a community college. It's just saying, let the locals decide if they want this, if they want to impose this tax on themselves. So I would encourage a yes vote on this bill.
Representative McGuire.
Ditto, vote aye.
See no further discussion, question being called. All those in favor of Chairman Burkhart's motion that when the committee of the whole rises to report a do pass recommendation that bill number 4 do pass. All those in favor say aye. Those opposed?
No.
Senate File 4 has passed the committee of the whole. The next bill for our consideration is Senate File 66. The reading clerk will read the bill.
Senate File 66, sponsored by Senator Cooper. Slayer rule applied to joint ownership. An act relating to wills, decedents, estates, and probate code. Mr. Speaker, your committee number 1 judiciary, to whom is referred Senate File 66 engrossed, Slayer rule applied to joint ownership. Respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Crago, Larson Dan, Oakley, Olson, Provenza, Rodriguez Williams, Washit, Yin, Sawanitzer. Representative Olson, Chairman.
You have heard the reading of the bill. What is your pleasure? Chairman Olson.
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report that it do so with recommendation that Senate File 66 do pass. I further move the adoption of the standing committee amendment. I'll turn over the explanation of the bill, and I'm assuming we'll take up the standing committee amendment after we've gone through the bill and when the timing is right. So I'll turn over the explanation of the bill to the good country lawyer.
Chairman Greer.
Okay, thank you, Mr. Chairman. And the reason for handing this over is we do have a policy decision here. So I cannot explain this bill without telling you of a terrible fact situation. Wherein a husband murdered his wife, his child, and then was surrounded by the police, and then shortly thereafter took his life. And with those terrible facts in mind, it creates some things in our probate law, and then also with how we deal with property in our American jurisprudence. And so, as most people, especially younger people in particular, hold their property typically as husband and wife or as joint tenants. So you see that joint tenants with rights of survivorship, and there's a couple different tenancies that still have the same component to it. We also do things like transfer on death. They're called transfers by operation of law as a general rule. You'll see those payable on death, a bank account that you may hold in your name, you would have transfer on death or payable on death to your spouse or to a child. You also see things like life insurance policies that go. And so all the years I practiced in Wyoming, I really never paid attention to this. This is a bill by my new senator for one of our constituents. And so when you talk about that, the joint tenancy, rights of survivorship, and the transfers on death, you get this situation that is actually very, on top of a tragic situation, it's even adds just more insult to the situation. Because when, in this case, the husband shot and killed his wife, that act alone transferred all of the property to him in that moment by law. And then when he took his life shortly thereafter, and because they did not have any surviving children, then all of his assets would either go according to his will, but in this case would go according to our intestate statutes, which were to his parents and siblings. And so the parents and the siblings and the other heirs of the spouse of the wife received nothing. And so what this bill does is seeks to remedy that situation and bring a sense of justice or fairness to it. And that's why it's called a Slayer rule, and it exists in many, many jurisdictions. It just never existed in Wyoming. And so the bill is quite simple with that. When you look on page 2, it provides that no person who feloniously takes or causes or procures another to take the life of another shall inherit. And inherit, so as we go down to the receive any property in joint tenancy with rights to survivorship, or there's tenancies by the entireties in Wyoming. And then inherit, receive, or otherwise take any property conveyed by the deceased person by beneficiary designation, transfers on death designation, payable on death, all those things I was telling about operation of law. And then also, which was put in by the Senate dealing with wills and trusts as well. And that's what the bill does. Now, the amendment, and the reason why the good chair of Judiciary said we'd handle the amendment is because there is a policy decision with amendment. And I truly do see both sides of the policy. And I think what I'd like to do is maybe with the help of the chair of Judiciary, we'll explain those two policies. And again, I can see both sides of that. So what I would like to do, Mr. Chairman, is divide the standing committee amendment. And I'll let you get that in your hand. And as I understand, I would like Division 1 to be lines 1 through 10. And then Division 2 to be lines 11 through 21. And if, well, I'll let the chair rule on that.
All right, Chairman Greer, just to clarify, you would want your request in Division 1, line 1 through 10, and then Division 2 would be 11 through 21.
That is correct, Mr. Chair.
Stand by, please.
Should be an easy division.
All right, Chairman Greer, council up here that is divisible. I'm going to start in Division number 1.
Okay, your chair's ruled it's divisible?
That is correct, sir.
Okay, thank you. So members with, just real quick with Division 1, it's basically a technical cleanup to catch up with the amendments that came over from the Senate. And so I would encourage a quick aye vote on Division 1.
Chairman Olson?
Yeah, and Mr. Chairman, just so the body, and I'm not sure maybe if we misspoke or we just maybe got it labeled wrong, but Division 1 is lines 1 through 10. So it's all of that. And all that is there was an amendment on the Senate side that dealt with these beneficiary pay on death and insurance designations that the good chairman of Minerals spoke about. And the original bill dealt with joint ownership. So all this does is bring Senate amendments into conform with the title. So this is a good amendment.
Question?
All right, we are voting on Division 1. All in favor, say aye. All opposed, no. Division 1 will pass. Chairman Greer, Division 2.
Okay, thank you, Mr. Chairman. So let me say okay, so the bill passes without Division 2. So we were to vote Division 2 down and the bill passes. What would then happen is all the jointly held property and the payable transfer on death property would go to the heirs of the victim in this scenario. So in this scenario, the wife, okay? If the amendment passes, what it says is that the moment before the victim is killed, the tenancies sever. And so what that means is on that joint ownership is at that point before the moment of death, half the property is owned by the wife and half is owned by the husband in this scenario. Meaning then after the tragedy is completed, half of the assets would go through the wife's estate in this scenario to her parents and siblings. And the other half would go to the husband's, okay, the person, the slayer, to his estate. And this is a tough decision because if you're talking about a second marriage situation and and the husband has children from the other marriage, okay, if you don't vote for the amendment, everything goes to the wife. And so it's a tough policy and there's no clear answer on it. And I just felt that it was necessary that we understand that make this vote. This bill is a great bill, regardless of how we decide this one single policy point. It doesn't make it bad one way or the other. I just didn't have a strong feeling one way or the other, and I can see both sides. And I felt, talking with the chairman of judiciary, it was important that we explain that to you and give this body the chance to make that policy decision.
Chairman Olson.
Yeah, thank you, Mr. Chairman. That's exactly right. I think the last part of what the good chairman of the minerals said is very important. Whether you adopt this amendment or not, it's a good bill. If you adopt the amendment, I still think it's a good bill. Either way, it's a good bill. And just to hone back in at least so a little bit more on this policy consideration, it really came down to blended families is what we're talking about. So Slayer rule exists all across the country in different states. The idea is hopefully fairly becoming really obvious. Slayer, a husband kills his wife. He shouldn't benefit from taking the property. The issue that this one particular amendment tries to address is the scenario of the blended family. So I've already got children, and then I get divorced, I get remarried, she has children. I have, let's say, for example, hundreds of years of history in Wyoming, whether that's mineral interest history or the family ranch. And then this individual takes the life of his wife. And now he shouldn't stand to benefit, and he won't. Under the Slayer rule, he doesn't benefit. But because of the way this amendment reads, it severs the right of survivorship prior to his death. He takes his own life, right? Prior to his death, which defaults the tenancy back to tenants in common. And as the good chairman of minerals said, when that happens, her interest in the property will pass to her heirs at law. His interest would pass to his heirs at law. So what it's that scenario where, his children are innocent to the crime, but the family ranch is now at stake. Do they get their half of the ranch and her children get her half of the ranch? And I think the other thing to consider here that's important is that none of this whole scenario doesn't really exist if you have the proper instrument in place. If you've got wills or trusts in place that direct specifically through all the various scenarios of who predeceases who, this isn't impacting that. This is going back to a concurrent estate. You've got a piece of land, you hold it as joint tenants with a right of survivorship. Now what happens? If they both share the same children, there's no effect because obviously the land would pass to their joint children. It's really that blended family, and it's really just a policy choice. So I think we both just really wanted to flesh out that policy choice so that the body knew the decision you're making. And I think either decision you make is a good decision, and the bill is a much needed bill. So there you have it, Mr. Chairman.
Representative Stiff.
Mr. Chairman, I just have a question for the effect of this division, if any, if the slayer survives. Just my question. So the question is, Mr. Chairman, if the slayer survives, what's the effect of this division if we pass it, if any?
Chairman Olson.
Mr. Chairman, that is a perfect question. And I just got that question on the side as well. And so yeah, we're walking through the scenario where the slayer takes his own life. That maybe is a little bit easier of a policy choice. Slayer survives. Slayer survives. He has joint property with his wife. The joint tenancy is severed. They become tenants in common. He doesn't get her half of the property. That would pass to her heirs at law because it's a tenant in common. He doesn't have the right of survivorship anymore. He would keep his half of the property. So that's another issue that the amendment does attempt to wrestle with, a little indirectly, is whether he should be divested of his vested interest in a property because of a crime he committed. Now, he committed a crime, but does that mean he gives up his half of the property interest? And this amendment would say, no, he doesn't. He doesn't get her half. He doesn't get her half. That passes to her heirs at law, but he would keep his half.
No other debate. We are on Division 2. All in favor, say aye. All opposed, say no. Division 2 will pass. Back on the bill.
Yeah, members, again, a good bill, and I encourage an aye vote. Thank you.
Question being called. Those in favor of Chairman Greer's motion that Committee of the Whole rise to report, do so with the recommendation that bill number Senate File 66 do pass. All those in favor say aye. All those opposed say no. Senate File 66 has passed the Committee of the Whole. Next bill for consideration will be Senate File 85. Reading clerk will read the bill.
Senate File 85, sponsored by Senator Ellis. Property tax reporting and exemption, an act relating to property taxation. Mr. Speaker, your committee number 3 revenue, to whom was referred Senate File 85 engrossed, property tax reporting and exemption, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Baker, Gray, Hallinan, Harshman, Henderson, Jennings, Roscoe, Sweeney, Yin. Representative Harshman, Chairman.
Representative Heiner. Mic on, please.
Privilege of the floor, please. Mr.
Proceed.
Chairman. Ladies and gentlemen of the chamber, I'd like to refer to 2 individuals on the north side of the chamber. They're county commissioners from the Lincoln County. They've traveled far distance to be here, and they have served in the great citizens of Lincoln County for many years. We have the chairman, Robert King, chairman, and vice chairman, Jerry Harmon. If you'd give them a round of applause, please.
Thank you for joining us. You have heard the reading of the bill. What is your pleasure, Chairman Harshman?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report it, do so with a recommendation that Senate File 85 do pass. There are no amendments, and I'd turn the explanation over to the co-sponsor from Natrona County, Representative Gray.
Representative Gray.
Thank you, Mr. Chairman. So SF 85, this bill does 2 things. We're dealing with personal property tax here. So this is the tax on personal property used in business. There are 38,000 tax accounts in Wyoming. And this bill does 2 things with 7,000 of those tax accounts. So we're talking about de minimis under $2,400. 1, it amends the penalties, which is that instead of a misdemeanor, which is a jailable offense, it becomes a late payment fee, $10 not to exceed $500 in total. This can be waived. Now, this is for everybody. Right now, it's a misdemeanor for failing to report, and we're a self-reporting state on personal property used in business. So this changes the penalty from a misdemeanor to a civil fee. And then the second thing this bill does is it creates a de minimis exemption. If a taxpayer has business property worth less than $2,400, it would be exempt from reporting and paying. This was a recommendation from the efficiency report that was commissioned 3 years ago. It's an efficiency. It reduces people's taxes. And I'd encourage an aye vote.
Chairman Eklund.
A quick question. I thought that the assessors are usually the ones that set what that tax should be. If you could clarify how that works, I'd be interested to know. Thank you.
Representative Gray.
Thank you, Mr. Chairman. Appreciate that question. Wyoming is a self-reporting state, but if the owner does not provide a list of all, if that list is not provided, the statute does allow the assessor to make the assessment based on quote unquote best information available. We did hear about that in committee. Thank you.
Representative Larson?
Yes,
Dan.
Mr. Chairman. Can you explain to me how they deal with these issues now when they don't get a report to the county assessor?
Chairman Zwana, sir.
Thank you, Mr. Chairman. I can try to answer that as a former chairman of revenue. And in most cases, your assessor makes their best guess on the personal property being reported by others in a similar class of a similar, let's say, small business. What this bill does and why I think it's somewhat counterintuitive, but it's really good because for especially people with very small businesses who are required by statute to report, they're having to, collect the information, send it in, mail it in, spend, I don't know, half an hour of their time on a stamp. And the assessor, has to spend 20 minutes of their time in paperwork and filing, $15, $20 of their time for each one of these. And you actually lose money at these de minimis amounts for your county assessor. So the county assessors actually really like this bill, the ones I've talked to, especially mine in this county, because it saves a huge amount of hassle on paperwork for low-level amounts of, $2 there, 70 cents there on what the actual tax is on this personal property. So I hope I answered that question, but for the really large personal property reports, if you don't turn it in, your assessor, does try to contact, in many cases, can look at previous, or they look at owners of a similar class and basically make their kind of best guess and charge you appropriately. And then you can agree, or you're more than welcome to come in and disagree with their finding and give them the information they want, or most people just say, okay, and move on.
Representative Newsom?
Thank you, Mr. Chairman. I have a question for the bringer of the bill. So if it's determined that I am exempt, do I still need to file this report every year at the risk of being charged maybe my tax is only $10. And if I'm a day late with filing my report, that's $10. So once you're determined to be exempt, you still have to file these reports.
Representative Gray? Correction, Representative, Chairman Zwana, sir.
Thank you, Mr. Chairman. The best answer is no. And again, you have to know how the system works where everyone is every time you buy something, you're supposed to pay, even from a friend or whatever, you're supposed to pay sales tax and remit it, right? Our statutes don't allow these exemptions. So everybody is supposed to pay tax on their personal property. For small businesses, your household items, a large percentage of people don't do that. And so what the bill is really trying to get at is what is this level of value that makes sense for your local county assessor to go through the administrative hassle of trying to charge people taxes because it's not worth the paperwork, either for their office or for those people submitting. And we heard lots of testimony over 2 years in the committee, and it did not make it in as a committee bill. And that's why the good sponsor down the hall brought as an individual bill, and she set that number at 2,400, and that was based on some discussions of, and it is different in every county. But if you do not believe you qualify and you're not close to that $2,400 threshold, you are exempt. And really, it would only be if the county assessor said, every other year you've been filing, can we just double check? We're just checking in, and you can swear a statement that no, you haven't. This would be 2,400. But no, you would not be required. It's really unless the county assessor believed you to be grossly infringing on your reporting. And I don't want to tell you how they know, but they have ways to kind of determine if people should be reporting who aren't, right? You file this paperwork with your banks, and you have EIN numbers, and you pay federal tax returns on your small business. And so they know generally who the large payers are. The 2,400, is it going to be within $100 either way? Doubtful. But I bet over 5,000 or 6,000, they're going to come give you a friendly call and say, do you have anything to report on your personal property tax this year? But the overall answer to the good Vice Chairwoman's question is no. If you don't think you fall under go above the threshold, you do not need to report.
Representative Larson, Dan.
Yes, Mr. Chairman, thank you. This has come to committee quite a few times. I was on revenue for 4 years, and I know it did at least a couple. And these discussions we had were kind of what we're having right now. It makes you wonder if the assessor is going to have more trouble trying to decide if they've got $2,400 worth of fair market value in personal property. And when you tax that, it's like $5 or $9. I mean, it's nothing. I just don't know if we really need this, if it gives the assessor, more work to do or not. It's a big question to me. So I'm against it.
Representative Ottman.
Thank you, Mr. Chairman. I just want to say at first, especially because of the efficiencies and what Senator Ellis was the senator was speaking with me about, I thought, oh, this is a great idea. And then I had the opportunity to speak with our county assessor, and she is adamantly opposed to it. So what I would like to say is just what she told me, because I'm still not knowing. It's rather confusing. But what she had told me was that no, it is not required in Wyoming for this tax, but people do report. And what her premise is two things. Number one, if people are not on the rolls and they are not assessed, then a lot of people don't realize, well, if you buy a new computer, a new tractor or whatever, and it's over $2,400, you're supposed to pay. I honestly didn't know we had this tax. So her premise is if people are not sent notices every year, then they don't reply back. And therefore there's taxes not collected from people that really do owe tax on, and they don't know. She also said that the way that people know, because she was told from other assessors that they drive around their counties, and when they see new property or new equipment or new whatever, then they know to contact those people. To me, that's picking and choosing over a lot of different things. The other thing is that it was brought to her is that if the $2,400 base is used, what about the people at $2,405? Is that fair? So what I'm suggesting to you is that we do just hash it out and make this policy decision if it's ours to make. Thank you.
Thank you. I'd like to remind the floor to make sure we don't use proper names within our debate. Thank you. Representative Sweeney.
Thank you, Mr. Chairman. So on and for the bill, we're talking about 7,184 personal property tax accounts out of the 38,441, which totals $47,202 out of the 134,630,548. So on a couple of comments on testimony we heard, no, not all the county and assessors are on board with this, but the majority, I would say, are probably in favor. And what does that $2,400 amount translate to? In most counties, depending upon what their assessment rates are, it translates to under $15 of tax on the 2,400. So what we heard in testimony, in my opinion, is very valid, that it's not even worth the postage to try to collect on some of these. And it did come up about 2,405. And I think there's got to be some latitude granted to our assessors, and this provides that decision-making process to our assessors, which they're already doing these sorts of things. So this is will, in my opinion, be a good save for our assessors. And I guess if they chose to opt out, they could. So, but on and for the bill.
All right, we are still on Senate File 85. Chairman's wanted to.
Thank you, Mr. Chairman. Just because it hasn't been said yet, and I think this is really important, I will be the first to tell you the $2,400, not exactly sure where that number came from, how it equates in your local tax base. But I do want to make sure you see 183205 in the bill. And if it's really easy if it's in color on your computer, but if you have the bill in front of you, you make sure you look at what we're taking out. Because right now, as I said, if you were required for even a de minimis amount for a $7 hammer, right? And you don't report that taxable property under our statute, you can be charged with a misdemeanor and fined 90 days in the county jail. That's the current statute that the bill, at least in this half of it, anticipates taking out to put a civil fine of $10 a day. So the second part of the bill, if we want to have a second reading amendment and debate what the right number should be, or if people, should have a threshold, I think that's great. But I would certainly encourage you to vote for the bill today to take out the misdemeanor and the imprisonment for, not paying a de minimis amount of your personal property tax that could be less than what it costs to do a stamp and time and a report. So that's a really good part of the bill that I think we've all agreed on in the interim. The second part, we can certainly have the debate over here about that tomorrow or third reading.
Representative Hallinan.
Thank you, Mr. Chairman. I think you all need to remember that this applies only to commercial property or ranch property. It's not what you buy. If you buy a computer, you don't have to pay this tax. It has to do with business property. And I think these amounts are such a small amount that the counties don't really benefit from trying to get these dollars. They pay more and as my previous speaker said, they pay more in collecting it than they do when they receive it. So for that reason, I think we need to support this bill. I think if anything, we might want to raise the amount of the exemption to maybe 5,000 or something like that. So there would be no further doubt about these very small dollars that are involved. Thank you, Mr. Chairman.
Representative Gray.
Thank you, Mr. Chairman. I think there's a couple amendments coming, but I really think of this bill as a win-win because it cuts people's taxes. It prevents this criminal misdemeanor for non-reporting, and it's an efficiency. So I think it's a win-win.
Question being called. All those in favor of Chairman Harshman's motion that when the committee of the whole rises to report, it do so the recommendation that Senate File 85 do pass. All those in favor say aye. All those opposed, no. Senate File 85 has passed the committee of the whole. Representative Jennings.
Thank you, Mr. Chairman. So after that robust debate and the one on Slayer, I'd ask you to stand up, and in the gallery is Mrs. Stivar and Katie Stivar. Their representative here was promised harm if he did this. So I thought I would like to introduce them.
Thank you for joining us. The next bill for your consideration is Senate File 111. Reading clerk will read the bill.
Senate File 111, sponsored by Senator Anderson. School of Energy Resources Budget Submittal. An act relating to the University of Wyoming. Mr. Speaker, your committee number 9, Minerals, Business and Economic Development, to whom was referred Senate File 111, School of Energy Resources Budget Submittal. Respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Bear, Burkhart, Duncan, Air, Greer, Heiner, Sherwood, Western. Noes, Representative Gray. Representative Greer, Chairman.
You have heard the reading of the bill. What is your pleasure? Chairman Greer.
Yeah, thank you, Mr. Chairman. I move that the Committee of the Whole rises report to do so with the recommendation that Senate File 111 do pass. Mr. Chairman, I also have a Committee of the Whole amendment, which is a technical correction. I would like to go ahead and move at this time. Okay, thank you. Members, I move our Committee of the Whole Amendment number 1 to Senate File 111. This is a technical correction. If you turn to page 2, line 10, it is simply correcting a typo in drafting where it says submit for review. Right now it reads submit review. The amendment changes that to submit for review. Pretty simple. I think everybody understands that. There's no questions.
All those in favor of Committee of the Whole Amendment number 1, say aye. All opposed, no. The amendment is adopted. Back in the bill.
Thank you, Mr. Chairman. For the explanation of the bill, I'll turn it over to the good Chairman of Transportation.
Chairman Burkhart.
Thank you, Mr. Chairman. So, ladies and gentlemen, this is a fairly straightforward, direct bill, but a little background for especially some of the newer members. School of Energy Resources, or SCR as we generally refer to it, has been in existence for about 12 years. This organization was set up by the legislature so that the legislature could, in effect, fund research into those things important to the state. We talk often about carbon capture, utilization, and sequestration. This is the organization that developed most of that technology that is now used and being looked at worldwide. Very good organization. And we funded it separate from the university. However, it is housed at the university as a place to put it. Currently, their budget is about $16 million. But if you look at their funding, a lot of it is by grants from a lot of our energy companies, even international energy companies, even energy companies outside of the United States. And that, along with the SCR, we established the Energy Resource Council, which is the advisory council to the School of Energy Resources. And I will tell you that that is probably one of the most highly qualified advisory boards or councils we have. These are industry leaders from around the country. Yeah, I'd really refer to it as probably a brain trust that we've developed. These are excellent people, also very approachable if you have technical questions or ideas you want to discuss with somebody. And that SCR has 27 people that do a variety of research based on the industry grants they get. And they also then use that grant money to provide other organizations with research money into other fields, agriculture, for example. It's not just all energy, and they've done a lot of work in those fields of how they can use their expertise to benefit the state of Wyoming. And they also fund a lot of energy projects. As I said, CCUS, some really projects which, frankly, from a technical standpoint, if they are proven correct, could actually change how we generate power in this country. They've done some excellent work in that area. And they're a worldwide leader in a lot of this research. And that the high bay facility that some of you have heard about. In fact, recently, one of the people in here said, I don't want to go through this 3D modeling program they have because when you put the headset on, it makes you seasick. And they're doing work at that level. Now, the issue with this bill is that we've always considered this body down the hall, SER's budget is strictly SER's budget. However, the university takes a different approach that they feel it is included in theirs and that they can do what they want with that budget. And that's where the disagreement comes in, and that's where this bill comes in to say that SER's budget is just that, it's SER's, and that they will present that budget separately from the universities. So at budget time, when the agencies go to before appropriations, SCR will go separately and not be included in the universities. And that's pretty much the gist of the whole bill. Just make sure that there's an understanding that their budget is separate from the universities, and it is controlled by the legislature who established that organization. And with that, I'll stand for questions.
Representative Simpson. Thank you, Mr. Chairman. Some questions for the bringer of the bill. So we're looking at page 2. So line 12 indicates then that we're going to strictly have the budget going to the governor. Does this essentially create a new agency under the governor? And a follow-up question, whose employees are they that work in this facility, in this center? Are they university employees or are they state employees? Who supervises them and who reports, does that supervisor report to?
Chairman Burkhart.
Thank you, Mr. Chairman. The first question, if you go to page 2, line 12, it says it shall submit its budget to the governor after approval by the Energy Resource Council. And actually, all agencies report their budget to the governor. While they also then, the governor adjusts them, then they go before the legislature's appropriations committee to do that. But this is normal. And the good representative has reviewed the budgets. So it's not creating a new agency. It's just the reporting relationship and the control of the budget. SER exists on its own, and the employees are their employees. They do not work directly for the university. They work for the School of Energy Resources. And then if you look on line 12 and 13, the Energy Resource Council is merely the advisory board or council to SER. They get first look at the budget, then it's submitted to the governor as part of the budget discussions.
Chairman Greer.
Thank you, Mr. Chairman. I do want to make one minor correction is the School of Energy Resources is a school within the University of Wyoming, and their employees are University of Wyoming employees. But from the very establishment of this school, this legislative directive is that, and you will, the good representative bring the question knows this from his budget book, you've got a separate division where that budget is set out separately, much like WWAMI is when you're reviewing that. And so, the bottom line here is while this has been funded separately for all these years, and if you'll recall in the budget last year, we dedicated close to $22 million for carbon capture and carbon technology research and porous fluid research for matching grants. Some of those matching grants, I think, were 12-1 in that one budget footnote. When the university received their budget reductions, there was a grab for all those funds. So if you're asking why are we doing this now, that is the reason why we're doing this now, is because those funds came from this body for a specific purpose for the benefit of the state of Wyoming, the development of our energy resources. So hopefully that answers that question.
Chairman Nicholas.
Thank you, Mr. Chairman. So I think we need to follow up with that just explanation, because it's my understanding that even though they may have sought to take those as part of their budget cuts, they weren't allowed to. And that we particularly the governor's office, specifically addressed those particular revenues, and we resolved the problem. And so other than that perhaps being a problem, has there been a need for do this in the past? And then more importantly, now you're going to have a separate board who's going to be monitoring those budgets and make submissions. And I mean, it's just a peculiar request. And, you know, currently the School of Energy Resources has always been kind of the pet project of the legislature. And so it kind of walks on water over at the UW compared to the other colleges, because we fund them more because they do more of what we like. And so this is taking that privilege, if you will, one more step. And I mean, I'm not sure that it's the right thing to do, other than maybe slap them on the wrist for their previous actions, but just further clarification of issues we've had with their budget.
Chairman Greer.
Yeah, thank you, Mr. Chairman. All relevant comments, but maybe not worded as well as they could have been. The Energy Resource Council does develop the budget and has developed the budget. That's been part of their duties and their jobs with respect to it. One of the things that was brought up is that a large share of the funding to the School of Energy Resources actually goes to other colleges for grants to pay to stand up programs. They were instrumental in standing up our MBA program, which quickly with their support grew to be one of the stronger online MBA programs in the state. They do the same thing with the engineering school. And if we look back at the folks that came before us 12, 14 years ago, the vision when they looked at our university and did not see any areas of excellence, this was one of those areas where they said, you know what, we can make a difference, or we're going to make a difference. And we're going to go ahead and help guide that along those ways. We talk about the High Bay Research Center, and we talk about the work there that's been done through the porous fluid movements. It is the premier research place in the world. You think you start jumping ahead of universities in Texas. That's saying something. It just really is. So with respect to the questions that were asked within this last budget is, yes, it was eventually resolved, and it wasn't that they didn't take it. It was that certain chairman of minerals had to dedicate a great deal of his time in meetings to ensure that it was agreed upon that they would back off of their position. And that's not appropriate either. So simple matter of it, simple matter is let them continue with their standard budget. If we have initiatives, so in last year, it was appropriate to put some of these matching funds within the School of Energy Resources. This year, because we have progressed to a scale up component, those funds for carbon capture sequestration were not parked with the School of Energy Resources. Okay, they're parked with the governor's office's oversight by the Wyoming Energy Authority, because we're moving forward with it. So I hope that answers some of those questions. I think this is a good move. Are there some sour grapes involved in this? There is in every piece of legislation.
Representative Duncan.
Thank you, Mr. Chairman. Just to make it really simple, it boils down to the fact that we have recently quite a bit of turnover at the university in administration, different philosophies, different beliefs, different ideas. And so this is a way for us to make it clear, concise, and an understanding of, we have two separations of the budget. This is one piece, it's a public-private partnership, and this is the other piece, it's a public partnership. And the legislature has a part in both of those, but this is to clearly delineate those lines and standards and lay everything out for future administrations, because we have a good relationship now, but there's not any guarantee that that's going to stay place in the future. So this just lines it out, has a nice smooth transition for the future, so that future administrations understand where the lines are and what the rules are and what the intentions are for these funds, on and for the bill.
Representative Simpson.
Thank you, Mr. Chairman. Ladies and gentlemen, I fully understand the sponsor's intentions here to protect the School of Energy Resources. I'm just not understanding the mechanism that we're approaching this on. We have employees of the University of Wyoming. Think about that. That means the director is an employee of the university. And on line 15, we're suggesting that their budget is just going to be passed to the university for information only. We've either got to sever that completely and set them up as an agency, or else allow the university to govern their own employees, one or the other. So I'm going to speak on and against this bill.
Chairman Zwanitzer.
Thank you. Just a question on page 2, and it's in section D. We didn't delete that the university's Board of Trustees still establishes a structure and the policies for the operation of the school. I mean, fundamentally, whoever controls the finances and the money, gets to establish what the policies and the structure are all. And so I don't know if that was a miss, that we should also delete that language, because now if it goes through the board right to the governor, the university, the Energy Resources Council, which I believe is made up of 2 legislators and energy industry executives. If it goes to them and then right to the governor, the Board of Trustees is basically left out of the picture, which is a policy question. But I don't understand why we would still leave that they have some role over the structures and policies for operation, and to still have some direction of the school, because financing is direction.
Any further discussion on the bill? Question being called. All those in favor of Chairman Harshman's Chairman Greer's motion that when the committee of the whole rises to report, to do so with the recommendation that Senate File 111 do pass. All those in favor say aye. All opposed say no. Senate File 111 do pass. Committee of the whole, the next bill for our consideration will be Senate File 126. The reading clerk will read the bill.
Senate File 126, sponsored by Senator Cooper. Real estate subdivisions, easement requirements, and act relating to planning and zoning. Mr. Speaker, your committee number 7, corporations, elections, and political subdivisions, to whom is referred Senate File 126 engrossed. Real estate subdivisions, easement requirements. Respectfully report, same back to the House with the recommendation that it do pass. Ayes, Representatives Blackburn, Clausen, Clifford, Duncan, Air, Hunt, McGuire, Roscoe, Swanitzer. Representative Swanitzer, Chairman.
You have heard the reading of the bill. What is your pleasure, Chairman Swanitzer?
Thank you, Mr. Chairman. I move in the committee of the whole rise to report, to do so with the recommendation that Senate File 126 do pass. There are no standing committee amendments, and I would turn it over to the good Chairman of Minerals.
Chairman Greer.
Thank you, Mr. Chairman. And I do hope this is the last time you have to hear from me today, members. So I bring you Senate File 126, which is a bill that gives some flexibility to our county commissioners in the realm of zoning, or excuse me, in the realm of establishing subdivisions. And so a lot of work, and I actually don't know the years. It's been 20 plus years. There was a lot of work that went in to our subdivision laws to try to bring some uniformity to them. And what you see, what we're directly looking at is in 185306 A, Romanet 5, and then we're in Cap A, capital A, deals with easements for water lines. And so as the laws exist today, and again, they're good laws and we're not changing those, is that if you're going to subdivide, you have to have an easement of 20 foot wide for your water line. Well, there still are scenarios out there where property had been subdivided more than 20 plus 30 years ago. For example, you'll see these old deeds, and those deeds will be in there and they'll just have maybe a 10-foot easement and for the water line. And So if you had, say, 100 acres and you sold off 75 of those acres and you saved 25 for yourself and you kept an easement, this was prior to the change in the law, that easement might only be 10 foot wide. And so now what the law says is that you could not subdivide your other 25 acres because that easement's only 10 foot wide. So that means you have to go to your neighbor and get permission or get the easement widened, in which case maybe you don't get along with your neighbor. Okay, that happens all over the world. But the simple fact of the matter is the burden of a water line, we're not talking about a road, we're talking about a water line. It's a pipe in the ground. The burden doesn't increase if there's one tap on the other end of the line or 10 taps. Just doesn't increase. And so what this is saying is that in those scenarios where you have those old easements that weren't drafted with the new laws or updated with the new laws, is all we're saying is that the county commissioners have discretion to issue a variance in those scenarios. And that is local control with a rational, thoughtful look at the circumstances and allow them the authority to do that. And that's what the bill does. Thank you.
Question being called. Those in favor of Chairman Zawaniter's motion that when the committee of the whole rise to report to do so, recommendation that bill number Senate File 126 do pass. All those in favor say aye. All those opposed? Senate File 126 is passed to committee of the whole. Correction. Representative Heiner.
Thank you, Mr. Chairman. I'd like to do another privilege of the floor.
Proceed.
Ladies and gentlemen, if you could stand up and give a warm welcome to another county commissioner on the west side. This is Eric South, Chairman of the Uinta County Commission in Uinta County. Let's give him a warm welcome.
Thank you, Commissioner, for joining us today. Representative Brown.
Privilege, Mr. Chairman.
Proceed.
Mr. Chairman and members of the body, I would like to introduce the first gentleman of House District 43. And I would also like to introduce, so Justin is his name, and then their friend Ty. Welcome to the House.
Welcome and thank you for joining us. Majority Floor Leader Summers.
Mr. Chairman, thank you. So I'm going to do a little reordering here. The next bill will be 139. And then I'm going to roll Senate File 38 down a ways. And so then after 139, we'll have Senate Joint Resolution 3, Senate File 114, Senate File 76, Senate File 142, and we'll see where that gets us for the evening. And then just to remember, the taco party is tonight, and we've only had 2 events all year. And so I will be stopping at 5 because it's important that we interact with everybody and those folks as well. So.
Thanks, sir. The next bill for your consideration is Senate File 139. The reading clerk will read the bill.
Senate File 139, sponsored by Senate Appropriations, Community-Based In-Home Service Program, an act relating to community-based in-home services. Mr. Speaker, your committee number 2 Appropriations, to whom is referred Senate File 139, Community-Based In-Home Services Program, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Kenner, Nicholas, Schwartz, Simpson, Stith, Walters. Excused, Representative Larson Lloyd. Representative Nicholas, Chairman.
You have heard the reading of the bill. What is your pleasure, Representative Larson Lloyd?
Mr. Chairman, I move that when the committee of the whole arises to report it, do so with the recommendation that
that bill number 139 do, that Senate file 139 do pass. And I'll turn the explanation over the bill to the good representative from the land of the Northwest.
Representative Schwartz.
Thank you, Mr. Chairman. So Senate File 139 on the face of it is a very simple bill. If you go to line 12, it shows that the community-based in-home services, which is a program in the department that manages the health of our citizens, will be funded subject to the availability of funds. So there's a backstory and an update with this bill. So the backstory is this has been an existing program that provides services to seniors who are still living in their homes, provides them homemaking, personal care, respite care for their caregivers, things like that. I personally consider it a critical service because it enables these seniors to stay in their homes rather than inevitably wind up in a nursing home, which not only is not as good for them or their families, but it's a burden on the state financially. So that's the backstory about what the program does. The update is, as you might recall, when we passed the budget bill, seems like weeks ago, but I believe it was yesterday, on agency number 48, there was a footnote number 13. And so what footnote number 13 did was restore the step 3 funding to this program. So although this bill anticipated there would not be funding at this time, what we have is a situation where there will be availability of funds, which I think is very good news. So despite the fact the money is there, I still urge an aye vote on the bill. Thank you.
Question being called. All those in favor of Representative Larson's motion that when the committee of the whole rises to report, do so, the recommendation that bill number Senate File 139 do pass. All those in favor say aye. All those opposed, no. Senate File 139 is passed to committee of the whole. Next bill for consideration will be Senate Joint Resolution number 3. Reading clerk will read the bill.
Senate Joint Resolution 3, sponsored by Senator Cooper. Federal suspension and orders on oil and gas production. A joint resolution requesting Congress and the federal government to reserve federal orders and actions that inhibit the safe development of oil and gas in Wyoming and that negatively and disproportionately impact Wyoming citizens and industries. Mr. Speaker, your committee number 9, Minerals, Business and Economic Development, to whom is referred Senate Joint Resolution 3 engrossed. Federal suspension of orders on oil and gas production. Respectfully report, same back to the House with the recommendation that do pass with the following amendments. Ayes, Representatives Bear, Burkhart, Duncan, Air, Gray, Greer, Heiner, Sherwood, Western. Representative Burkhart, acting chairman.
You have heard the reading of the bill. What is your pleasure, Representative Duncan?
Excuse me. Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, to do so with the recommendation that Senate File Joint Resolution 3 do pass. And to explain the bill, the good representative in coal country.
Thank you, Representative Bear.
Thank you, Mr. Chairman. I bring you Senate Joint Resolution number 3 and ask you for your favorable consideration. This resolution is where we're asking Congress and the federal administration to reverse actions and executive orders which affect Wyoming negatively. This is a result of a request from our executive branch, and they have asked us to back them up and support their efforts to push back on the federal government. Since the request was made, the executive has joined a lawsuit with several states that effectively block the legal means by which the federal government is attacking our way of life. So we call that the stick. This measure is a carrot. Some will say that a carrot works better than a stick. I'm not sure which is going to work better here in this situation, but I do believe that this body should make every effort to protect our state's economy, and this is one effort to do so. With that, I will present the bill. We have many whereases, and I will simply point out the ones that I sense you will be most interested in. Many of these whereases are important, though, for the people that will be receiving this resolution in our nation's capital, who may not be very familiar with how things work on the ground here in Wyoming. So with that, we began by stating that we have abundant resources which supply energy throughout the country. Moving to page 2, we point out that due to the responsible manner in which we extract our resources, we provide a safe and environmentally practical way to produce these energy resources. We point out the sheer volume of land and minerals controlled by the federal government, the negative effects of banning production in our state's economy. We specify the particular executive orders in which the federal government has created and the need for our response. Executive Order 13990 stopped all federal leasing, and number 14008 indefinitely pauses federal leasing for oil and gas production. On page 3, we point out how federal agencies have reacted with orders of their own, which elevate the burden on our industry even further. At the bottom of page 3, we find what I believe is one of the most important points regarding these orders. As is stated in the orders themselves, the purpose is to evaluate the environmental impact of on these federal leases. We're pointing out that if that is the goal, what they're actually doing is driving industry to other parts of the world that have fewer regulations and fewer environmental protections. We heard lots of testimony that this particular play for oil and the price that we see elevated right now is likely to last for the next 10 years. So there's a great deal of demand, and somewhere that demand is going to be met. If it's met overseas, then the pollution is going to be much greater than it would be if we simply extracted these materials here and kept the economy in Wyoming going. On to page 4. We point out the effect of these actions on our citizens here in Wyoming. In particular, we anticipate at least 20,000 to be affected who either directly or indirectly work in the oil and gas industry here in Wyoming. At this time, Mr. Chairman, I'd like to move Standing Committee Amendment number 1 to Senate Joint Resolution number 3 and explain the amendment.
Proceed.
So this amendment, we're simply adding 7% to that number of 20,000. 7% is the total employment that's going to be affected. And the reason we do that is 20,000 may not seem like a lot when you're in Washington, D.C. So we simply want them to understand just what kind of impact this is going to have on our population. And with that, I will stand for questions and ask the question.
You've heard the motion on the standing committee amendment. Are you ready for the question? Standing committee amendment number 1 has, correction. Question has been called. All those in favor say aye. All those opposed say no. Standing committee amendment number 1 has been adopted. We are back in the bill.
So now moving on, we now get to the therefores and in statement in section 1, we request the administration of our nation rescind, reverse, or repeal the executive orders that were issued in January of 2021 that suspend or pause oil and gas leasing on federal land in Wyoming. Section 2 asks the executive to direct all agencies to do the same for orders which they have promulgated in this area. Section 3 on the next page, we make the statement on behalf of this body, including the body across the building, opposing the actions of 2 particular federal agencies, one named for those things inside, but that regulates things that are outside, as well as the agency that protects the air we breathe and the water we drink. We state that the effect of these orders is to increase the burden on those companies and facilities in Wyoming in an attempt to achieve climate-related goals that are truly unrealistic and that disproportionately impact the people of Wyoming. Section 4, we state that we strongly support our national delegation's efforts to prevent the executive from unilaterally using suspensions and moratoriums on energy development. Section 5, we strongly encourage further congressional action to protect responsible leasing and permitting in Wyoming. In Section 6, we direct the Wyoming Secretary of the entire state to transmit this resolution to the federal executive, the heads of the agencies I mentioned earlier, and to the presiding officers of the two houses of our National Congress. This being a resolution, it does require a 2/3 of this body to pass. And with that, I stand for questions.
Question being called. All those in favor of Representative Duncan's motion that when the committee of the whole rise due report, that it do so with the recommendation that Senate Joint Resolution number 3 do pass. All those in favor say aye. All those opposed, no. Senate Joint Resolution 3 has passed the committee of the whole. Next bill for our consideration will be Senate File 114. The reading clerk will read the bill.
Senate File 114, sponsored by Senator Boner. State land leases, an act relating to state lands. Mr. Speaker, your committee number 5, Agriculture, State and Public Lands and Water Resources, to whom is referred Senate File 114 engrossed, state land leases, respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Blackburn, Clausen, Eklund, Fortner, Heiner, Larson, Dan, Western, Wharf, Winter. Representative Eklund, Chairman.
You have heard the reading of the bill. What is your pleasure? Chairman Eklund.
Mr. Chairman, I move that when the committee of the whole rises to report it, do so with the recommendation that Senate File 114 do pass. And there are 2 amendments on it, and I'll move those and probably dispense with the first one and then work the other amendment into the bill and explain it as I go. So there was a committee of the whole amendment. When we started researching that amendment, we found some little problems that really helped to correct the bill. So I would ask for an aye vote on the standing committee amendment number 1. Hold on. Mr. Chairman, did I say aye? I would ask for a no vote on the standing committee amendment.
You've heard the motion of the standing committee amendment. Question been called. All those in favor say aye. All those opposed, no.
No.
Standing committee amendment number 1 has failed. We're back in the bill.
Okay, Mr. Chairman, I will try to explain this bill. I'm not on this bill because I didn't understand it when it was first presented to me, mainly because I didn't know what they were talking about with vacant lands, vacant state lands. And now that I understand the problems that exist and the glitches that the Board of Land Commissioners got into in awarding leases on them, I think I'm qualified to finally explain this bill. There are rarely, but sometimes lands that become vacant, state lands become vacant, and the leases are allowed to lapse for whatever reason. We're only talking about vacant lands. We're not talking about the preferent laws on the other leased lands and how those leases renew or any of that part of the conversation. This simply directs the Board of Land Commissioners to award the leases on these vacant lands. So if you start in on page 2, you'll see a bit of changing from line 1, just of language, through line 12 and 13. And then the meat of the change comes from 13, Romanette I. Romanette I says that the lessees need to be occupants of adjoining lands with good standing of the board. Then we get into the second committee of the whole amendment, which is mine, and I would move that amendment, and I'll continue to explain it. I don't think, did I move it earlier?
Yes, sir, you did.
Okay, it is moved then.
Oh.
Okay.
Correction. If you could go ahead and
I will
committee.
move the committee of the whole amendment number I imagine it's number 1. I've got the wrong numbers on here, to Senate
sir.
File 114.
Proceed.
So, so the preference has to be given to occupants of adjoining lands. And then we come in with Romanet 2. And the state of right under Romanet 1, that would be about line 18. The State Board of Land Commissioners shall award the lease of vacant lands as set forth in this paragraph. And then in this paragraph, it has the preferences and the competing bidders if there are more than one. And how that preference is set up is determined in here. Then we got, if you'll read through page 3, the amendment takes qualified out in every place that it's at. So on line 2, you remove qualified. Let me explain why we needed to do that. When we started digging into the statutes, we found that qualified applicant was defined in the other preference law. So we needed to, rather than creating another ambiguity for a confusing part in the statutes, we needed to remove it here, and they would just be applicants. So we've removed the qualified, and if there aren't any, and then renumbered, and if there aren't any questions on why that was done, I would move that amendment and ask a question.
All right, all those in favor, committee of the whole, amendment number 1, say aye. Opposed, no. The amendment is adopted. Back in the bill. Chairman Greer.
Thank you, Mr. Chairman. For the good chairman of agriculture, so it always has been that you had a Wyoming citizen who had use for the land and who had adjoining land. And so you've taken that adjoining land component out of there. What discussion was had regarding access to the state lease, to the state lands? Because some of this is in holdings that are miles away from a road. And even across 2 or 3 different landowners. And there's not always an easement into that. You've always used your own lands to access the state lease. So if another party comes in, they don't have access, they don't have adjoining properties. Did you discuss what would happen with access?
Mr. Chairman, there, that's how part of the problem was created. There were leases that were awarded to people that had no access to the land except for a helicopter or something. I think that one of the people that was affected by this case and the need for the change might be able to correct me on that, but we're not taking away the ability of the adjoining landowners to be participants in the leasing of this land. And I think I understood you to say that. We're being certain that they are considered, and this is just on vacant lands. It doesn't pertain to the other leases. We seem to have pretty clear rules on those.
Representative Clausen.
So thank you, Mr. Chairman. To speak to the good chairman of minerals question, it's in here. If you go to page 2, lines 15 through 17, the preference is still given. This bill is very specific to when the rare occasion comes that there's a vacant land and there's 2 peoples with preference, that's where it's pointed to. It's a very pointed specific.
Representative Larson.
Thank you, Mr. Chairman. You know, I'm struggling with this preference deal because the example that the good chairman from Minerals brings up is valid. If you had If you had private ownership all around a state parcel, I could see where this would be a legitimate approach to it. But it isn't always. And I agree with the good chairman of ag that these vacant lands don't always come up. But you may have a vacant piece come up where there is access, or that's next to a road, or next to everything. And you're saying that preference has to be given to an adjoining owner or lessee. They get preference over everybody else, over you, over whoever that may be. I don't think that's right. And I think that this needs a little more definition. I think that we're giving this preference to the adjoining owners runs a little bit of, well, you've heard my points. Thank you, Mr.
Chairman Greer.
Chairman. Thank you, Mr. Chairman. So to the last gentleman, I disagree with him. To my prior question, I asked it poorly. So page 2, lines 7 and 8, what we're doing there with this bill is as a condition to apply, as a condition, a prerequisite to being able to apply, there's 3 things that have to be met in the law right now. You have to be Wyoming citizen, you have to have use of the land, and you have to have adjoining lands. So now we're taking that condition, that prerequisite, and we're changing that, lowering that down to a preference. And so that was my question, is when you do that and you have landlocked lands, how do you deal with that issue of the access?
Representative Walters.
Thank you, Mr. Chairman. And to try and offer a little more explanation here. So in existing law, there's subsection A that I don't think is, subsection A is not shown in here. So it says all state lands leased by the State Board of Land Commissioners for grazing and other agricultural purposes shall be leased in a manner and to such parties as shall inure to the greatest benefit to the state land trust beneficiaries. And so the issue really comes about because of the way the office was interpreting this. They were saying that that was the #1 priority. And so then when you get to the good question about what happens when there's no access to these lands and the office gives a lease to somebody that doesn't, then when you get into B and it says you have actual and necessary use for the land and access to it. And the issue becomes when the office is giving priority or offering leases to people that have no access to the land, but they're willing to pay more. Because in subsection A, it says it has to be to the greatest benefit of the state trust beneficiaries. And so that's what this bill is trying to address, is how do you make sure that the person who may have offered a slightly lesser amount for the lease, but has the actual access to the land, can have a preference to get at that. And that's where there's been some major consternation here, is because if you have no access to get the land, but you're willing to offer a really high price, it doesn't really benefit anybody. And so it's the conflict between subsection A and subsection B that is trying to be resolved with this bill. And it's been through multiple iterations, and I still don't know that we're to the best place we can get it, but I think it does start to give a process to the office of how to make sure somebody that has the actual access to the land can have an opportunity to match a bid or get close to the bid or get to the live auction process with somebody that has no access to the land but was willing to bid far more. Again, it's the conflict between A and B that has caused problems within this office. And this is the way, one way to try and address it. There is a period at the end of subsection A that some will tell you is a drafting issue in the courts. And so that period means something that says A should be held in higher regard than subsection B. Others don't believe that to be the case. I'm not a lawyer, nor am I a legislative drafter. But like I said, this is an issue to try and resolve how A and B work together. I'm sorry, A is not in the bill, but if you look it up in 36.5.105, you can read these two differences, and that's where the issue arises. And this is the best result we could come up with thus far.
Representative Larson.
Thank you, Mr. Chairman. I'd like to thank my good desk mate on appropriations for the clarity that he provided in the corrections that we're trying to make. He may not be a lawyer, but I think those who are could learn on how to explain from him very well. Thank you.
Representative Nyman.
Thank you, Mr. Chairman. One consideration you also may have to keep in mind, and I deal with this at home. I have a section 36 and I have another landowner that joins it. When we look at this, a lot of times special consideration is given to those that surround the property because there's also an expense that comes in. If they lease that property to someone else, the state will have to come in and pay for 50% of the fencing on 4 miles of fence around a 640 acre parcel of property. So that's an expense that the state would have to incur if another leasee was to take over that piece of property that was not around it or immediately adjacent to it many times. So that would be an extra expense that's not being considered in this. So that would be another reason why we would want to give preference to those that are immediately around it. It would in effect be a cost savings to the state. Ultimately, 4 miles of fence, I don't know what it is right now, but I would say that's in our country, that's about $20,000 to $30,000. And so something to consider.
Question being called. All those in favor of Chairman Eklund's motion that when the committee of the whole rises to report, it do so with the recommendation that bill number Senate File 114 do pass. All those in favor say aye. All those opposed say no. Senate File 114 has passed the committee of the whole. And I would like to take a privilege of the floor. I'd like to acknowledge, I know he's up there talking, our Adjutant General, Major General Porter. He's in the back gallery up there. Thank you. Thank you, sir, for joining us. Majority Floor Leader.
Mr. Chairman, I move that the committee of the whole rise and report.
You've heard the motion on the floor. All say aye. Opposed, no. Motion carries.
Reading clerk, please read the committee of the whole report.
Mr. Speaker, your committee of the whole, having had under consideration bills on general file, begs leaves to report as follows. Senate File 118 do pass amended. Senate File 78 do pass. Senate File 75 do pass amended. Senate File 4 do pass amended. Senate File 66 do pass amended. Senate File 85 do pass. Senate File 111 do pass amended. Senate File 126 do pass. Senate File 139 do pass. Senate Joint Resolution 3 do pass amended. Senate File 114 do pass amended. Representative Burt, Chairman.
Chairman Burt.
I move the adoption of the committee of the whole report.
You've heard the motion. All those in favor of the adoption of the committee of the whole report, please say aye. Those opposed, no. Congratulations, Marine Burt. Hoorah. Hoorah. All right, members, we're going to tidy up some more business, signing of enrolled acts, messages from the Senate, reports from standing committees. We're at that order of business of signing of enrolled acts. The first enrolled act for our consideration is
House Enrolled Act 48. There being original House Bill 115.
House Enrolled Act 48, original House Bill 115, an act relating to game and fish, lowering the minimum age at which a person may take a big or trophy game animal as specified and provided for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act number 48, being original House Bill 115. I have so signed. Next Enrolled Act 49.
House Enrolled Act 49, being original House Bill 144, an act relating to multi-purpose vehicles, amending the definition to exempt multi-purpose vehicles and motorcycles from the plug-in electric vehicle annual decal and fee, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 49, being original House Bill 144. I have so signed, and I apologize. The first bill I signed was Representative Paxton. The second one I just signed, Representative Brown. Congratulations. Next Enrolled Act, Senate 25.
Senate Enrolled Act 25, being original Senate File 88, an act relating to property and conveyances, specifying ownership of fossils, artifacts, and non-fossilized animal remains discovered in split estates, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Senate Enrolled Act 25, being original Senate File 88. I have so signed. Next Enrolled Act 26.
Senate Enrolled Act 26, being original Senate File 74, an act relating to athletic trainers, broadening definitions under the Wyoming Athletic Trainers Licensing Act to expand athletic trainers' scope of practice, authorizing the provision of telehealth services, authorizing the provision of additional services during a declared state of an emergency, requiring rulemaking and providing for an effective dates, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 26, being original Senate File 74. I have so signed. Next Enrolled Act 27, Senate.
Senate Enrolled Act 27, being original Senate File 106, an act relating to highways and transportation, inserting additional license plates in the replacement duplicate plates process, clarifying dealer permitted fees, repealing obsolete and unnecessary definitions and fees, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 27, Senate, being original Senate File 106. I have so signed. Next Enrolled Act 28, Senate.
Senate Enrolled Act 28, being original Senate File 107, an act relating to highways and transportation, including alternative fuels in the fuel tax exemption, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 28, being original Senate File 107. I have so signed. Next Enrolled Act 29.
Senate Enrolled Act 29, being original Senate File 108, an act relating to education, changing terminology from the vocational education to career and technical education for purposes of K-12 education, specifying applicability and providing for the effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 29, being original Senate File 108. I have so signed. Next Enrolled Act 30.
Senate Enrolled Act 30, being original Senate File 110, an act relating to small claims procedures, amending procedures governing services of summons, authorizing actions to be brought in the county where the cause of action or some part thereof arose, specifying applicability and providing for the effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 30, being original Senate File 110. I have so signed. Next Enrolled Act 31.
Senate Enrolled Act 31, being original Senate File 116, an act relating to administration of the government, reducing the number of voting directors of the Wyoming Business Council as specified, and providing for effective dates, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 31, being original, Senate File 116. I have so signed. Next Enrolled Act is 32, Senate.
Senate Enrolled Act 32, being original Senate File 124. An act relating to trade and commerce, amending prohibitions against unfair trade or commerce discrimination, authorizing investigatory powers for the Attorney General for antitrust claims, providing for civil penalties and additional civil remedies relating to the antitrust violations as specified, amending criminal penalties for antitrust violations as specified, clarifying the applicability of manufacturing requirements to discrimination provisions, amending and repealing provisions related to the authority and duties of enforcing authorities, and providing for an effective date, being enacted by the legislature of the state of Wyoming.
I'm about to sign Enrolled Act 32, being original Senate File 124. I have so signed. Messages from the Senate.
Message 338. Mr. Speaker, House Bill 10, COVID-19 Large Business Relief Program. The House bill listed above passed on third reading in an amended form as follows by the vote indicated. Ayes 21, noes 9. The Senate respectfully asks the House to concur by adopting the listed amendments. Sincerely, Ellen Thompson, Senate Chief Clerk. Message 339. Mr. Speaker, House Bill 102, Wyoming Preference Act of 1971 amendments. The House bill listed above passed on third reading in an amended form as followed by the vote indicated. Ayes 30. The Senate respectfully asks the House to concur by adopting the listed amendments. Sincerely, Ellen Thompson, Senate Chief Clerk. Message 340. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 115, Big or Trophy Game Animal Minimum Hunting Age. Ayes 29, noes 1. Sincerely, Ellen Thompson, Senate Chief Clerk. Message 341. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. House Bill 144, Electric Vehicle Fee Updates. Ayes 28, noes 2. Sincerely, Ellen Thompson, Senate Chief Clerk. Message 342. Mr. Speaker, the bill listed below failed to pass the Senate on third reading by the vote indicated. House Bill 19, Antique Motor Vehicles. Ayes 15, noes 15. Sincerely, Ellen Thompson, Senate Chief Clerk. Message 343. Mr. Speaker, House Bill 38, Community Behavioral Health Priority Populations. The House bill listed above passed on third reading in an amended form as follows by the vote indicated. Ayes 20, noes 10. The Senate respectfully asks the House to concur by adopting the listed amendments. Sincerely, Ellen Thompson, Senate Chief Clerk. Message 344. Mr. Speaker, House Bill 150, State Budgeting and Expenditure Authority. The House bill listed above passed on third reading in an amended form as follows by the votes indicated. Gonna get to the end. Ayes 27, noes 3. The Senate respectfully asks the House to concur by adopting the listed amendments. Sincerely, Ellen Thompson, Senate Chief Clerk. Message 345. Mr. Speaker, House Bill 95, Game Road Kill. The House bill listed above passed on third reading in an amended form as follows by the vote indicated. Ayes 19, noes 14. The Senate respectfully asks the House to concur by adopting the listed amendments. Sincerely, Ellen Thompson, Senate Chief Clerk. Message 358, conferees appointed. Mr. Speaker, the Senate conferees to meet with the like committee number 1 from the House on amendments to Senate File 25. The Senate conferees are Senator Boner, Chairman, Senator Bouchard, Senator French. Sincerely, Ellen Thompson, Senate Chief Clerk.
Thank you. So members, I'm going to appoint committee to conference on Senate File 25, the message you just heard. Chairman Greer, Walters, Crago. I'm also going to assign conference committee on House Bill 22. And You're going to hear Chairman Greer's name in this one as well. He happened to be very involved in both of these bills. So it'd be Greer Chairman, Larson Dan, and Oakley, House Bill 22 conference. Standing committee reports.
Mr. Speaker, your committee number 2 appropriations, to whom was referred Senate File 121 engrossed, state funds, investment and distributions. Respectful report, same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Kenner, Larson Lloyd, Nicholas, Schwartz, Simpson, Stith, Walters. Representative Nicholas, Chairman.
Mr. Majority Floor Leader.
Mr. Speaker, I move that the House adjourn until 10 a.m. tomorrow, the 31st day of March, 2021.
Committee announcements. Committee announcements. Chairman Paxton.
Thank you, Mr. Speaker. Your committee number 4, Education, will meet tomorrow upon noon recess in E3 to continue discussing Senate File 127, Earn While You Learn, and Senate Joint Resolution 4, School Capital Construction Constitutional Amendment.
Earn while you learn. That seems like an appropriate thing for the Wyoming legislature. Chairman Nicholas.
Thank you, Mr. Speaker. Your House Appropriations will meet on adjournment to hear the re-referral of Senate File 122 in room 301.
Representative Duncan.
Thank you, Mr. Speaker. Your Minerals Committee number 9 will be having a joint interim topic meeting tomorrow morning at 8:30, I believe in Extension Room 4.
Thank you, Vice Chairman. Any other announcements? Any other announcements? Mr. Majority Floor Leader.
Mr. Speaker, I'd like to provide the committee of the whole list for tomorrow. There'll be maybe a couple more bills, a few more coming out of committee, and Thursday may be abbreviated. I don't know. If we do any on Thursday, then they'll be advanced from second to third reading on Friday. So we try to get our third reading done on Friday on any bills coming out of committee of the whole on Thursday. So tomorrow's committee of the whole list is Senate File 34, 157, 130, 152, 76, 82, 38, 121, 141, 142, and 68.
Thank you very much. Chairman Olson.
Yeah, sorry, Mr. Speaker. Sometimes I'm asleep at the wheel, but I always arrive at my destination. And your committee number 1, Judiciary, will meet tomorrow at 8 a.m. to consider jointly with the Senate interim topics at 8 a.m. in E005. Thank you.
Thank you very much, members. Just so you're aware, at 2:59 today, Chief Clerk sent out concurrent requests. So those concurrence requests are on 5 bills. So check your emails for 2:59. So we'll be taking those up tomorrow. And then any conference committee reports that may come out. Any further announcements? I'll once again remind members that as we're signing lots of bills, the governor's office is doing their best to accommodate signing ceremonies. So please contact the governor's office if you want to make those arrangements. All right, seeing no further business, you've heard the majority floor leader's motion that the Wyoming Legislature, House of Representatives, 66 Wyoming Legislature adjourn its 29th day and reconvene at 10 a.m. Wednesday, March 30th. All those in favor, please say aye. All those opposed, no. We are adjourned. We are adjourned until 10 a.m., March 31st. Well done, members. Thank you, Mr. Speaker Pro Tem. Thank you, Chairman Burt.